All right, good morning, everyone. We're going to go ahead and get started. This is the state all-purpose calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and today is May 16th of 2024. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at these proceedings today. This particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on to this proceeding and watch. Today, we will address a variety of matters, including taking pleas and set bonds as necessary. All right, have all members of the Public Defender's Office been able to interview their clients?
Good morning, Judge. Yes, Mr. McLean and I have interviewed just about every client. I believe we have two people that we do need to speak with.
Okay, well, let's get started. Who do we have first at ACDC?
Morning, Your Honor. We have
Good morning.
before you 29 and 30, Ms. Bertina Thurman.
And Judge, this is somebody that we do need to speak with. I'm happy to speak with her on the phone, or because Mr. McLean is not here yet, I'm happy to address someone else and I can speak with her when he gets here. So we're not holding things up with whichever way you prefer.
I can call you at
Okay, that's fine. All right, so I guess we'll be on hold. There's no other matter we can take up.
Your Honor, we can actually still continue in courtroom 2.
Is Ms. McLean there?
No, I have some of Ms. Vigilante's clients here in courtroom 2.
Well, she's got to go call ACDC.
Your Honor, I do believe position 18 and his attorney are both here virtually. Perhaps we could start.
Okay, well, we can do that one. Let's do that one. And position 18 is, I apologize if I'm pronouncing this incorrectly. Mateen Jafar, can you pronounce it for me?
It's Mateen Jafarzadeh.
Jafarzadeh. All right. And what is the announcement for Mr. Jafarzadeh's case this morning?
Your Honor, I'm Encore Trivedi. I used to be a DUI defense attorney. I've since stopped, but Mr. Jafarzadeh was picked up on a bench warrant from a 2017 case. I mean, I'm here on his behalf because I'm still counsel of record, but I would have to say that I'm otherwise mostly ineffective.
Okay, that's an interesting.
I mean, just for what it's worth, you know, as far as the probable cause hearing goes, I mean, it's a bench warrant. I don't think there's much of a defense.
No, I don't think that's what we're addressing today. Ms. Falk, do we know what we're doing with Mr. Jafarzadeh today?
He made bond. He's not in jail no more, Judge.
Oh, he's made bond. So, okay.
He made a cash bond on the case back on May the 11th of 2024.
Okay,
He's present on the screen, so I don't know if they want to deal with his case or send the case back to the.
Right, that's what I was asking. Is there an offer to resolve it today, Ms. Falk?
There is not, but I can fashion one and send it to the attorney.
Okay.
Because we had the same information that he had already been released, and normally on SAP we don't.
Right, there's nothing to do. Correct.
Okay. Ms. Falk, should I just contact you at your office?
Well, what we'll do is if you'll just sit tight, I can text you on the chat in here in Zoom the recommendation. If it's something you wish to take, then you can speak with your client. I can send you over some plea paperwork and we can handle it today.
Okay.
And that will be the end of it.
We'll stand by.
And Ms. Falk might take a really good look at the age of it and decide the state.
Noted the age of it, Your Honor. Thank you.
The state might have some other thoughts. Yes.
Okay. Sounds good. Thank you.
Thank you both. Okay. Are there any other matters we could take up? It doesn't look like it. Ms. Lewis, is there an add-on today?
Yes, there is, Judge. I hope you received it. Did you get the announcements?
I did not. That's
okay, I'll send it over to you right now. These were resets from Tuesday SAP calendar, and we do have the competency counter, and we do have a DV counter. We do not have no probation counter today.
All right.
So I will send you. Did you get the DV calendar?
Nope.
Okay, I'll send those two.
You know, I'm not on that normal. No one chooses.
Okay, I'll send those two over to you right now.
All right, wonderful. We're gonna be on a very brief hold. Thank you all.
Try to have my thoughts on,
Okay, good.
Hey, Matt, turn your screen off. I'm gonna call you.
All right, are we ready to continue?
Yes, Your Honor, we are ready to proceed with Ms. Thurman. She is interested in entering a negotiated plea this morning.
Okay, so we're taking a plea as to 29 and then 30 will end up being the no cross.
Yes, ma'am.
Is Ms. Falk? Oh, Ms. Falk is back. Ms. Falk, will you give us the recommendation, please? You're muted. It's okay.
I just noticed. The state's recommendation, Your Honor, on this case is 12 months served, 42 days, credit for time served, 21 days. That is going to be from August 8th, 2023 to September 6th, 2023, and then May 6th, 2024 to today. The balance is probated. Stay away from 2833 Palm Drive in East Point. No further contact with Joey Burton. On count 2, the obstruction of the officer, the state's recommendation is going to be 12 months to run concurrent with count 1. And we're also going to ask for a $300 fine. Let me see. We would like to sound at this time for Mr. Joey Burton.
All right, is Mr. Burton on the line and wishes to make a statement?
And we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
Do you so stipulate?
So stipulated.
All right, and that was your understanding of the offer?
Yes, Your Honor, and if I may just ask, Your Honor, and also Ms. Fox, because the probation requirement is really just paying a fee and staying away from this gentleman, would you consider a non-reporting status on probation upon payment of that fine?
Let me just check one thing really quickly.
I'm off alert, you know,
My apologies, Your Honor. I just wanted to go over history really quickly and see
That's
what
okay.
we're doing. State's not agreeable to that.
Okay.
Her history and the incident at hand. This wasn't, Your Honor, this wasn't a regular criminal trespass where she just happened to be on Kroger, parking lot. She actually damaged the property of the person she was dating at the time.
Can I have the history since you looked at it, Ms. Falk, and found it persuasive?
Of course, Your Honor. So she has 6 cycles, and it includes a criminal trespass from 2017. Let me just make sure it's not this one, which is our current case. She also had a disorderly conduct in 2019, giving false names. She pled nolo to that, got 12 months suspended sentence and 2 days confinement. Then she had 2 FTAs, one in 2021 and one in 2023, as well as a battery family violence in 2024 and a cruelty to children in the 3rd degree. That's out of the Chamblee Police Department. So that's what I found to be persuasive, that, this happened in 2017 and that was her first offense. And then she's just continued racking up offenses since then.
Okay, Ms. Vigilante, if she takes the plea today, what I would do is I would require her to report the entire time, but I would waive 3 months of the fees. Would that be something agreeable?
Yes, Your Honor, thank you.
All right, so let's ask Ms. Thurman some questions. Ms. Thurman, please raise your right hand. Oh, excuse me. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right. Did anyone force you to take a plea today?
No.
Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
And you understand you'll have no further court dates and you're giving up your right to a trial by judge or jury by taking a plea today?
Yes, ma'am.
And you understand the requirements? You can't have any contact with Mr. Burton and you
Yes.
can't go back to that location. You understand that?
Yes, ma'am.
You also understand that there's a fine you'll be responsible for.
Yes, ma'am.
All right. As to the charges of criminal trespass and obstruction, how do you plead, Ms. Thurman?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Falk or Ms. Vigilante?
No,
No,
Your
Your Honor.
All right. Best of luck to you, Ms. Thurman.
Thank you.
Justin Johnson.
Justin Johnson, I didn't talk to me though. Oh, talk to her for me, okay?
Your Honor, we're gonna go to position number 5, Mr. Tion Coney.
Okay, let's see. Position 5. Okay. All right, Mr. Tony, good afternoon. Your case is 24 CR 0026815F. You're charged with loitering and prowling. Do you understand your rights today?
Yes, ma'am.
All right, and the announcement for this case?
Your Honor, Mr. Coney would like to enter a plea this morning, so we just asked the court to accept the recommendation of the state.
All right, Mr. Graham, if you put the offer onto the record, please.
Yes, good morning, Your Honor. The
Good
state's
morning.
recommendation in this case is 12 months to serve 4 days, credit for time served 2 days.
Yes.
That's the period from February 27th through February 28th, 2024. Balance suspended and a stay away from the incident location, which was 200 North Avenue, the Burge parking deck at Georgia Tech.
All right, and that was your understanding, Ms. Vigilante, and you stipulate to factual basis, ID, and venue?
Yes, Your Honor, that was our understanding and we do stipulate.
All right, Mr. Coney, I'm gonna place you under oath to take a plea. and to make sure that you are taking this plea voluntarily, all right? Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
And you understand that by taking a plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you understand the requirements that you cannot go back to the location?
Yes, ma'am.
All right. As to the charges previously listed, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional?
Um,
Not from you. Let your attorney speak for you, okay? If you have something, please tell her and let her convey that to me. Is there anything additional from
No,
state or
yeah.
defense?
Thank
Nothing further, Your Honor.
All right. Best of luck to you, Mr. Coney. That concludes your case.
Thank you. Yeah. If they do decide to take me back as a job.
Your Honor, I sure hate to interrupt. This is Foss Hodges speaking, attorney for Mr. Aluba, who is, I think, was position 1 on this calendar. If you tell me to stop talking, I will stop talking.
No, that's okay. Is Mr. Aluba even at courtroom 2?
So I'm in the courthouse. I filed a late entry just yesterday. I thought this was an in-person hearing. I've just gotten the link, so he's in custody.
Right.
Hold
on one second. Let me see if is he at courtroom 2?
Your Honor, he's not in courtroom 2, and the state has not made any recommendation on his case this morning, so there isn't too much to address.
Okay. So Ms. Falk is going to add something. Has that changed? Do you have a recommendation now, Ms. Falk?
Well, Your Honor, the state's recommendation is that we are going to ask the DA's office to review this case for a potential transfer.
Okay. So it looks like what we're going to do, the transfer has not been the case has not been accepted, correct?
No, Your Honor. We just received the full police report yesterday, and after reviewing that police report, I would like the DA's office to take a look at this case.
Okay. So what we're going to do is, in the event that they don't accept it, we don't want the case to get lost. So let's reset him. Miss Lewis, what does it look like for SAP in 2 weeks?
2 weeks.
Yes.
Today's the 16th. It's the 30th.
Is it full?
No.
Okay, we're gonna put Mr. Aluba on the May 30th calendar. And that should give you time, Mr. Hodges, to make contact with your client, see if the state if it is accepted by the DA. If not, discuss potential resolution with Ms. Falk. All right?
Yes, Your Honor. Just for the court's knowledge and the state's knowledge, I've spoken with the DA's office. There's a companion felony case already in the DA's or already in Superior Court. And so I think the state DA's office reached out to the solicitor yesterday to try to talk about that. So I think the whole case will be bound over there. So
okay. So that may
Sorry, Your Honor. I wasn't trying to talk over you. My apologies. Mr. Hodges, do you know which attorney you spoke to with the DA's office?
Juliana Peterson.
Juliana Peterson. Okay. I'll
Yes.
reach out to Ms. Peterson. Thank you so much.
Right.
So do
Thank
we
you.
still think the reset is necessary? Do you still want to reset this?
Your
2
Honor,
weeks?
I would still prefer to reset this 2 weeks just to keep it on the radar. I know how things tend to fall through the cracks.
I do. Okay. So we will reset position 1 further note to the May 30th calendar, and it may be reset for the notice or bound over to a Superior Court. Mr. Hodges, does that conclude your business?
That's all I have, Your Honor. Thank you for letting me butt in. Appreciate
All right,
it.
no problem. This calendar is always kind of like a moving bus station, so you take care.
Very good. Thank you.
All right, bye-bye.
Next
All
one,
right.
position number 10 and position number 11, Mr. Davis Wilkins.
All right, I'm sorry. 10 and 11.
Ms. Vigiletti's not ready.
I apologize, Judge.
Okay.
That's okay.
We,
Judge, did you receive your calendars?
Yes, ma'am. Thank you, Ms. Lewis. I appreciate that.
I apologize, Your Honor. We are ready to proceed with Mr. Davis Wilkins. This is position 10 and 11.
Okay. All right, I'm ready. Mr. Wilkins, Mr. Davis Wilkins, my apologies. Your case is 22 CR 003577Y. In this case, you're charged with battery family violence. Do you understand your rights?
Yes, ma'am.
All right, and the announcement, Ms. Vigilante.
Mr. Wilkins would like to enter a plea of not guilty this morning. I am happy to file a waiver of his arraignment.
All right, that's fine. Are we addressing bond?
No, Your Honor.
Okay. Well, okay, so Mr. Davis Wilkins, your attorney is gonna file some documents that's gonna reset your case for trial. That will give her more time to work on this matter. That doesn't necessarily mean that you're going to trial. It just means that we will not be taking any actions today. And it will be reset to a division judge, all right?
Thank you, Judge.
All right, best of luck to you, sir.
How long does it take me to buy? Thank you.
Okay.
Thank you, Your Honor.
Next, Your Honor, we're gonna go to the add-on calendar. It's gonna be add-on number 4, Mr. Charles Thomas.
Uh-oh, hold on.
Come on.
I said I had it, but I didn't. It was not open. Hold on. I got it though. Miss Lewis is all over it. Position 4, you said?
Yes,
All right, this is Mr. Charles Thomas.
it is.
All right, Mr. Thomas, your case is 24 CR 001890F, in which you are charged with criminal trespass. Do you understand your rights today?
Yes, ma'am.
All right. Mr. McLean, the announcement?
It's a negotiated plea, Your Honor.
All right. Taking some notes. All right, Ms. Falk, if you would put the recommendation on.
Yes, Your Honor. Let me just pull that up briefly. I too missed the add-on calendar completely, but I have the
It
recommendations.
happens. It
I have
happens.
the resets from Tuesday. All right. So the recommendation in this case for Mr. Thomas was 12 months to serve 66 days, credit for time served. Well, actually, we'd move that up to 68 days, credit for time served 30. Well, actually, that's wrong. 70 days, credit for time served 35 days. Sorry, I'm doing math on the fly here. That's from April 15th, 2024 to today. Balance suspended. Stay away from Target at 3660 Marketplace Boulevard in College Park. So again, that's 12 months, serve 70 days, credit for time served 35 days from April 15th, 2024 to today. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
We do so stipulate for the purposes of the plea. Let me comment on the negotiated plea though. 2 days ago, it was 66. The crime didn't get any worse in the last 2 days, so we could leave it at 66 and increase the credit days. It'll be more than adequate to cover the 66.
Okay. Well, the only reason I did it is because 2 days has passed, so I
Right.
just those 2 days. So
Well,
No.
he have any, I'm bad at math. I have to check. Either way, he doesn't serve any more time.
right, if it's 30, serves 35.
Okay.
70, serve 35, he doesn't serve any time. If it's 66, serve 35, he doesn't serve any additional time. I'm fine either way.
Okay, so we'll go with it as requested by defense then.
Thank you.
Mr. McLean, you did so stipulate?
We did.
All right. And before we go forward, the state is requesting a no further contact with Ms. Palmore. Let me make sure she's not present. Is there a Diana Palmore? Is that, you look confused, Ms. Falk. There was no, oh, I'm sorry, I'm looking at the wrong one. I forgot we're on the add-on. There's no stay away, forgive me.
Not a
I get all messed up when I don't print these things out ahead of time. Okay, back to it.
You're on.
Yes, Palmore, you're on a different case.
Ms.
My
Palmore,
apologies.
right, Ms. Palmore, I'm sorry I sounded for you. The case that you are associated with is being reset to another day. Okay, so you'll get a new notice about when to show up. But I'm glad I did sound for you, so now you are free to go, okay? Take care. Have a good day.
Thank you, Ms. Palmore.
All right, back to the add-on. And sir, you do Mr. McLean, you do stipulate, and that was your understanding, just making sure before we go forward.
Right. The condition here is simply stay away from Target.
Okay. That's correct.
Can y'all
All right, Miss,
clarify the amount of time? Cause y'all was back and forth on that and I got 68, I got 66. Please clarify.
Miss Lewis will do 66 with credit for time served 35. Thank you so
Okay.
much.
Thank
I
you.
apologize for the confusion on my part.
No problem.
and mine, I'm sure I didn't help. All right, Mr. Thomas, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Then you understand by taking the plea, you will have no further opportunity to contest these charges before a judge or jury? And you understand the requirements of the sentence? You can't go back to that target? All right, as to the charge, Mr. Thomas, of criminal trespass, how do you plead?
Yeah.
I accept your guilty plea at this time. Is there anything additional?
Nothing, Your Honor. Thank you.
All right, Mr. Thomas, best of luck to you. That concludes your case.
Thank you, ma'am. All right, let's see. We'll go to the third one.
Next, Your Honor, we're gonna go to position 16 and position 17. Mr. Robert Hopkins.
All right, good afternoon. Still morning. Good morning, Mr. Hoskins. Your case is 22 CR 0063332E. In that case, you're charged with theft by shoplifting, and 17 is an FTA. Do you understand your rights today?
Yes, ma'am.
All right. Ms. Falk, I'm sorry, I have a negotiated plea. Is that still correct?
This one, number 16, 17, Your Honor, this one I believe was,
We requested a 1-week reset, Your Honor. There's an additional theft by shoplifting case that was not on the calendar, which is 24 CR 001-270E.
And the state's not prepared to make a global offer today?
Not at this moment, Your Honor, so we would ask for a reset. It doesn't even need to be a 1-week reset. If we could just do this on the 21st, if the clerk is able to do this as an add-on. If not, we can just do a 1-week reset, but I would like to do this as a global rec.
and let me ask, what was the date of alleged occurrence on the case ending in 1270E?
Let me just check. I believe that's going to be, let me just pull that up. It looks like the date of that offense was on September 4th of 2022.
Okay.
Ms. Lewis, is there room to put it on Tuesday? You're muted, Ms. Lewis. Can we put it on Tuesday, Ms. Lewis? You're muted.
Can we put on next
No.
Thursday? We got 52
Okay.
folks on Tuesday counter and it just went out.
Okay, so we don't have a choice but to reset it to next Thursday. Okay, Mr. McLean, so we will reset Mr. Hoskins' case to Thursday's SAP calendar. Do you wish to be heard on bond today?
Yes, Your Honor, given the circumstances, Mr. Hopkins is wondering whether the court could see its way clear to allowing him to wait on the outside for next Thursday.
All right, well, let's hear our bond. What is his current bond? Let's hear a bond argument then. All right, Ms. Falk, if you give us the state's position on bond.
Let me unmute myself. So the cases as they are set forth, let me just pull up this one really quickly. So currently the defendant has these 2 theft by shoplifting cases. The first one was from January 2nd of 2022. On that case, the defendant had an FTA that was dated, it looks like a warrant was issued August 2nd of 2023 for his failure to appear in court. In that particular case, according to the incident report, the defendant was bound over from the municipal court from an incident from January 2nd, 2021, where officers were dispatched to Walmart at 1105 Research Center in reference to a shopping. A $184.01 of clothing was stolen, as well as some 2 cases of beer by the defendant. On the second case that the defendant has, I understand it's not on the calendar, but I still think it is relevant to this discussion. That case happened in September of 2022. The defendant on that case, this was also a municipal court bindover. On that case, on September 4th of 2022, the defendant went to the Walmart at 1105 Research Center, which was the same one as the previous one. The defendant had stolen 14 items of merchandise and was arrested as he was trying to exit with the merchandise, passing all points of sale. We would point out that this defendant's history is 57 cycles, which is why the state asked for a 1-week reset. We want to go through and actually make sure that he is not a recidivist theft by shoplifter. His history includes burglaries, giving false name, criminal trespass, disorderly conduct, probation violations, and these are all convictions. Giving false name, another criminal trespass, that takes us to 2003, kind of moving through this a little more quickly. He also has parole violations, willful obstruction of law enforcement officer, criminal trespass, theft by receiving stolen property, theft by taking, theft by shoplifting in DeKalb Superior Court, which he received 10 years for. Let's see, forgery in the 4th degree, more criminal trespass charges. His most recent conviction was a criminal trespass charge in 2023 in Clayton County State Court, for which he received 30 days in jail. And so the state just wanted an opportunity to kind of review these cases and make sure, especially given that one of them was a felony for which he got sentenced for 10 years on a theft by shoplifting, that this wasn't a recidivist case and didn't need to be upgraded. So that's why we did ask for the 1-week reset. That is why the bond was set as it was, including the fact that the defendant did not show up for court, and we asked that the bond remain as set.
Okay. What is the current bond? I don't think I heard that part on either one.
Yes, Your Honor. So the bond on this case is currently set at
$2,000, Shirley.
Yeah,
Okay.
I believe it is 2,000.
2,000 on this case. What about the other one? The one that's not on this calendar?
The other case, he actually was given, it looks like maybe it was a bind over from municipal court. So he actually is not in jail on the other case. He's in jail on this case for the FTA.
All right. Mr. McLean, your response.
Your Honor, he paroled out to his sister's address. He has two bases of stability. One is that he will end up living at his sister's address as soon as he's out of this jail, even if that's today. And he has been in close contact with, when he was homeless prior, he used the social work services of First Presbyterian. They don't house people, but they have some pretty awesome social services for mail drop and for food when necessary. So he states to the court that he's going to be stable. This criminal arrest business is over with him, and he'd like to be out and come back to court at a future day.
All right. All right. I'm going to convert Mr. Hoskins' surety bond to a signature bond through the jail with the same requirements that previously existed. So this case will no longer be holding him in the Fulton County Jail.
Thank you, Your Honor.
All right. Mr. McLean, if you'll send that bond order over at the conclusion of the calendar today.
That bond order will actually be on 17, the FTA, if I'm correct, right?
Oh, I guess so.
Yeah, it's a FTA he's in jail for. So yes, you will have to indicate the FTA number on there. It was the bond, it was the FTA that's set by judge.
I'll make sure we put the right number on it. Thank you.
Okay. All right.
Good luck to you, Mr. Hobson.
All right.
And he needs to update his address to make sure we got a good address on record for both of the cases now.
Okay. Mr. McLean, did you hear Ms. Lewis? Please make sure his address is updated so that we don't have, he's getting a second chance in spite of that FTA, so he needs to be present and attend all other court dates. I hope your client understands the importance of that.
I believe he does. I've got his sister's phone number and I can always call the parole board and get hold of the address and compare it to theirs. I'm sure it'll be.
All right. Best of luck to you, sir. That concludes the case. Who do we have next?
Position number 28, Henry Thomas.
That's a not guilty bond request.
Are you asking to be, you are asking to be heard on bond?
Yeah, sure. Excuse me. You want to be, you want to do the.
Okay, Mr. Henry's, okay, I was gonna read the case number. All right, hold on. This is Henry Thomas, correct?
Yeah, we're muted. No, we're not. No, we're not. Okay, sorry. He'd like to switch that to a non-negotiated plea, Your Honor.
Okay, this is Henry Thomas, just making
Yes.
sure. All right, Mr. Thomas, your case is 24 CR 002734E. In this case, you're charged with battery. Do you understand your rights?
Yes, Your Honor.
All right. And Mr. McLean, you said the announcement is no longer not guilty. It's a non-negotiated plea?
Yes, Your Honor. The issue would be the number of extra days. If any, he would be asking for the time served on the jail portion.
All right, who do we have from pretrial today? Mr. Howard? Oh, Mr. Howard, you there?
Yes, I'm here. Waiting on my coworker to get here.
Thank you for filling in. We appreciate your service this morning. Can you please give us this defendant's history?
Yeah, hold on. It's 75. Last arrest was 2023 probation, another 2023 probation. Identity theft fraud conviction. He's on probation for that out of Jackson County. Forgery conviction, another forgery conviction, 2023. 2021 forgery conviction. Disorderly conduct conviction, 2020. What else? Got FTAs from 2015, probation, and more FTAs from 2014. That's it.
Okay, thank you. Ms. Falk?
Yes, Your Honor. This is on April 15th, 2024. The officers responded to a person injured call at 401 Windsor Street Southwest. She stated she had been assaulted by the defendant. Her face was severely beaten to the point she was unrecognizable. She had to have been choked several times, hit to the back of her head twice. And her face was severely swollen with abrasions as if she had been beaten with an object. Both eyes were swollen shut along with injuries to her neck area. She was transported to the hospital. She advised that she and the defendant were not in a relationship, that he had told her, "I'll show you, bitch, you're going to submit to me." She stated that he and another male who was also homeless advised that there was another individual also involved in the beating of this victim. And Miss Elizabeth Pittenger advised she saw the defendant punch the victim a couple of times from the rear as they were walking. The defendant was then placed under arrest and charged. I will say that this was a pretty, even, as far as the report reads from the officer, a pretty violent beating. There was really severe injuries to the face of this victim. That, coupled with the fact that this defendant has 70 plus cycles gives the state some great concern about what was happening here and the fact that the defendant was openly striking her in public in front of everyone, including witnesses, which indicates a pretty callous attitude toward the safety and health of this victim, Ms. Savoy. And for that reason, the state made our recommendation. That recommendation is going to be, let me just pull that up for a moment. 12 months served 90 days, credit for time served 15 days. That's going to be from May 2nd of 2024 to today. No further contact with Julie Savoy. Stay away from the 400 block of Windsor Street in Atlanta. 12 weeks anger management and 120 hours of community service. At this time, we would like to sound for Ms. Julie Savoy, and we would ask the defense stipulate to the manufactual basis and identification for this offense.
Just prior to doing that, could we have the state read what she said was the source of her facial injuries?
Hold on, before we do that, let's sound for Miss Savoy. Let's see if she's here. Miss Savoy, are you here and wish to make a statement? And I don't see anyone with that name on the screen. Okay, Ms. Falk, if you wish to answer Mr. McLean's question, please do
Right.
so.
She did originally say another female had battered her, but the arrestee was reported to have choked her several times and hit her to the back of the head twice. So whether it was as a party to a crime of beating her or he was the sole offender, he was involved in her beating.
I was never clear from the police report on who made the allegation of any choke. That's right.
Okay, so Mr. McLean, your position is, would you like to tell me anything else? I know you have concerns about jail time.
Your
But
Honor,
other than that, what would you like me to consider?
I believe that he was arrested 15 days before our arrest date showing in our records. He has told me that he was arrested in another place and then under this warrant and then brought here. So that would be, but even by looking at our records, it would say that he came from another jail. I have not, because of the speed with which we do SAP, I've not been able to yet check that out. I was just talking to him, met him yesterday, but if he's correct about having an extra 15 days, that was the reason why he was in the other jail, was simply to wait on coming to Fulton County Jail. What was that jail, sir?
Ms. Lewis, are you able to see that for me? Whether he has the was booked in, or Ms. Falk, whether he was booked in earlier on this charge?
No, he wasn't. If he was booked in somewhere else, it's not indicating that because the jail just has the day that he was booked in, what Ms. Falk has indicated from May the 2nd, which was his arrest date. And he's been in jail for 15 days as of today.
Right.
And Your Honor, not only that, if he was in jail at a different place for another charge and a hold was placed on him to bring him here, the jail's not going to give him credit for that time.
No, they're not.
Sitting in jail somewhere else is not our problem.
Right, okay. Mr. McLean, anything else you'd like me to consider?
ACDC was where he was picked up from to be brought over here. If there was a hold on him for this case, it would count, I believe, for credit. Because that would, had he made bond on whatever was, if there was another charge, which we don't have in front of us, if there was another charge, had he made bond on that other charge, he would not have been free to go. So that's why it would be fair to give him credit for that detention.
And my response to that is we're arguing over time that we have no proof of. So state's recommendation is the state's recommendation.
Oh, he's going to pull out a citation. Let's see what we got.
Give me a second.
Let's see, this is one of those yellow things, arrest citation. I don't know. 4/15/24. I can't read the time because it is, one of those MCR paper things. It says he was arrested for battery, Atlanta, warrant number W something. Gosh, I think it ends in 11 or 16. And the reason he was arrested on 4/15 is in that the accused did, that's the printed part, have an outstanding City of Atlanta warrant number EW-04387, looks like 16, battery. I think that's this case, isn't it? Place of offense had been 401 Windsor. And that is the address that we're talking about. So I think I think he was arrested on our warrant.
And what's that date?
4/15, the tax day, April 15th, the Ides of April.
Let me look up. Let me try to look my.
I can send a copy of this to the state.
I would appreciate that.
I
Thank you.
think so. I think Ms. Falk needs to review it as to
Now
why.
Oh, he's also got, let's see what else there is. Disorderly conduct. Yeah. Got 2 tickets from the same moment. So just hold on. I'm explaining it to the court.
Why don't we let Mr. McLean, why don't you send that to Ms. Falk? Let her
Right.
take a look at it and then we'll come back to this. Because
Right.
that's
In all candor to the court, he does have both disorderly conduct and arrest on this from 4/15 forward.
well, let's let Ms. Falk look at it and see if that changes the state's position as to the time. And let's take someone else and I'll put a note that we'll come back to this
Very
position.
good. Thank you.
Okay, we have positions 33 and 34, Mr. Walker.
Oh, that looks like a plea, Your Honor.
All right. All right, good morning, Mr. Walker. Your case is 22 CR 00728. I'm sorry, 7258A, and what you're charged with theft by taking. And there's an FTA for you. Do you understand your rights this morning?
Yes, ma'am.
Oh, you also have a possession of marijuana charge. It was at the bottom. My apologies. All right, and you said this is a negotiated plea, Mr. McLean?
Yes, it is, Your Honor.
Okay. All right, Ms. Falk?
Yes, Your Honor. On the theft by taking count 1, state's recommendation is 12 months, served 20 days, credit for time served 10 days. That's going to be from July 20th, 2022 to July. Okay, let me take a look at that because the calculation date is wrong. Balance probated, stay away from MARTA at 5 Point Station, 40 hours community service, no further contact with Q1 Rice, anti-theft course, and we are holding for restitution. We would ask that restitution stay open for 30 days on this victim. On count 2, the possession of marijuana less than an ounce, the state is agreeing to a null pros. We are also agreeing to dismiss the failure to appear charge. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and we would like to sound for Mr. Rice.
All right, this is Kuwan Rice present on the Zoom conference and wishes to make a statement. All right, Mr. McLean, do you so stipulate? Was that your understanding?
Yes, Your Honor, for the purpose of the plea, we do so stipulate. Let me point out in candor to the court that it's the police report had an S instead of a W, so I think it's Kusan Rice.
Oh, is Kusan Rice present? Okay, where's Mr. Walker? Is he gone?
He's on
Right
jail
here.
court on phone.
Oh, okay, all right.
And-
Mr. Walker, please raise your right hand.
Yes,
Do you
ma'am.
swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
All right, you can put your hand down. Mr. McLean, was there something else you wanted to tell me before I take his plea line of
Yes, Your
questioning?
Honor. He understands the elements of the plea, but I was wondering this. He understands the 40 hours of community service. But the police report was pretty clear that the iPhone was quickly recovered over at the next, I think the next stop on the MARTA train. So would there be any restitution? Was there any damage or loss?
I'll go back and double check. If that's the case, then the state would waive the restitution. We would also like to put on the record that the defendant was in jail from May 9th, 2024 to today, which is how we got the 10 days.
May 9th, okay.
Yeah. So it was July 20th to July 21st of 2022, and then May 9th, 2024 to today.
All right, Ms. Falk, are you able to quickly look at that police report to see if we need to leave the restitution open? Because it is our preference to close it if it's not.
We'll go ahead and close out that restitution, Your Honor.
All right, so no restitution. All right, Mr. Walker, reminding you you're under oath. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
Excuse me?
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that by taking the plea, you're not going to have any further court dates regarding these charges?
Yes, ma'am.
And you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand the requirements, the course that you have to take, and the community service?
Yes, ma'am.
All right, as to the charge of theft by taking, how do you plead, Mr. Walker?
Yes, ma'am. I
No,
plead guilty.
All right, I accept your guilty plea. Is there anything additional from the state or defense?
No, Your Honor.
Whatever the attorney says, I like.
Okay, thank you, Mr. Walker. All right, that concludes your case. Best of luck to you, all right?
All right, thank you.
What happens to his probation? Does he continue on it?
Say that again?
What happened to his
He's gonna-
probation? Does he
He's gonna have
continue?
to, because he has requirements, so it has to be balanced probated. He's got to do community service.
I got that. I was just wondering if it's non-reporting or he continue or it's suspended. That's what I was trying to figure out.
Oh, what's the, does the defense have a request?
Well, we would request that it go non-reporting or suspended or terminated after he completes his 40 hours. He should be able to knock that up pretty quickly. Mr. Walker, let's see. Mr. Walker, is he still there?
Do you need them? I can grab them.
Well, I
Miss-
just need to make
Ms.
sure.
Falk, your position on the non-reporting?
We don't object to going non-reporting, Your Honor.
All right, so once he's finished the requirements, he can go non-reporting.
Just if the deputy would, when they're getting probation, I make sure to give him the address. Just double check that he's still got the paper where I gave him the 132 Mitchell. Thanks.
Okay, I'll make sure he gets that 132 Mitchell Street.
Right. He has a piece of paper for me on that, so.
Okay, I'll give him that address.
And I think I'll visit him as soon as court's over with as well, just to make sure. All right,
Okay.
thank you.
Yeah. Next, we have positions number 2 and 3, Mr. Anderson.
All right, Mr. Anderson.
Ms. Vigilante's on the phone right now with another client.
Okay, can we take someone else?
We can go to position 40 and 41, Mr. Montez Williams, 40 and 41.
Okay, Mr. Williams, your cases are, one is an FTA, but this case is 23 CR 007474A. You are charged with criminal trespass and damage to property. You understand your rights?
Your Honor, this was one where I had indicated social worker visit needed first, I believe. Is that correct?
All right, so are you asking for a short reset?
Yes, Your Honor. If we have somebody that can interview him today, great. Otherwise, I might need to reset it a few days.
Are the social workers coming as part of the other calendar later today, Mr. McLean? Do you know?
Do we know if our social worker is going to?
It was part on the competency calendar.
I'm sorry.
Part on the competency
Tasha, the
calendar.
social worker, I'm on Zoom. If Mr. McLean needs me to speak with him, it would have to be a breakout, but I'm on Zoom.
Sure.
Oh, okay.
So there we are. So, if we could do a breakout at some point when convenient.
Okay, is there someone else at jail court's iPhone? We could do the breakout. I don't know, is there a way to do that breakout, Ms. McLean? You have a laptop? So we can keep
I
going,
have-
or Ms. Vigilante have one that you could use?
When the room is free of all inmates besides him, we could do the breakout right here at this screen.
Okay, I was hoping we could do it and keep going, but all right, I guess we'll have no choice. We'll come back to Mr. Williams then.
I don't know.
Or Ms. Vigilante, you have a laptop?
Your Honor, Zoom does not work on my laptop. I use my cell phone. Mr. McLean is welcome to use my cell phone to Zoom if that's helpful.
I think,
Okay,
I think I could sign in, but, I would have,
if Kasha could do that on while we're going, that would be helpful so that we don't hold for that entire breakout, if possible. If not, we make it work as best we can. All right, who do we have next in the meantime?
We'll all be in the session together, so I'll have to go to medical records and hold the cell phone by the window because we have bad signal in the courtroom.
Okay, all right, can we take someone else?
Yes, we have positions 2 and 3, Mr. Anderson, I'm sorry.
Mr. Anderson, your case is 24 CR 002012Y. You are charged with simple battery family violence. Do you understand your rights? Oh, and you also have 24 CR 002013Y, in which you have the same charge. Do you understand your rights?
Yeah, ma'am.
All right, and the announcement for this, Ms. Vigilante?
Your Honor, Mr. Anderson would like to discuss the possibility of a non-negotiated plea this morning.
Okay, non-negotiated, Mr. Howard, can I have the history, please? Is Mr. Howard still here? Oh,
No,
it's
Your
Ms.
Honor,
White.
I'm here. Yes,
Well-
I'm here. Can you give me 1 second? You can come back to me.
Oh, all right, I guess, Mr. Graham, do you have the history?
Your Honor, I do have 12 total cycles. Have arrested in 2013 for battery family violence. A 2011 arrest, a fugitive from Louisiana, which is simple assault case, and the one previous that was 1998, a simple battery. Your Honor, in the case ending in 1-2Y, that took place on July 29, 2023. Law enforcement responded to a domestic dispute at 1302 Cahaba Drive Southwest in Atlanta. Upon arrival, the victim, Andrea Jones, advised that an argument with Ronald Anderson became physical when he headbutted her and bit her on the face during the altercation. Mr. Anderson had fled the scene before the officers arrived. And the second incident, Your Honor, case ending in 3Y, took place April 17, 2024. Law enforcement responded to a dispute call at the same location. The same victim advised that she and Mr. Anderson were arguing over a book bag. She placed her things in the bag. When she attempted to leave the residence, Mr. Anderson approached her from behind, told her to give him the book bag, or saying that it was his book bag. He then grabbed the book bag, taking it from her. He hit her with it several times, and then he punched her in the face with a closed fist, pulled her by the hair before throwing food on her. The officer did observe abrasions to her lower lip and bruising right side of her face in that case. Your Honor, the state's recommendation in the case is 12 months, or as a global recommendation, 12 months, served 90 days, credit for time served 30 days. That's the period from April 17th until today. Balance probated, we're asking for no further contact with Andrea Jones, a stay away from 1302 Cahaba Drive Southwest, 60 hours of community service. And for the second case, also 12 months, served 90 days, credit for time served 30 days, April 17th through today. Balance probated, no further contact, stay away. FVIP, no firearms. And that one concurrent with the previous sentence. So a total of 12 months, served 90 days, credit for time served 30 days, April 17th through 2020, April 17th through today. Balance probated, FVIP, we're still going to ask for no further contact with Andrea Jones. Stay away from 1302 Cahaba Drive Southwest, 60 hours community service. And Your Honor, the reason for that recommendation is because both these incidents involve the same victim, short amount of time, and Mr. Anderson's history is he's got a violent history and a tendency to physically assault the victims in the cases. And that is the reason for the recommendation, Your Honor.
All right, let's sound for Ms. Jones. Is Ms. Jones present? I don't see anyone with that name. Mr. Jordan, can we put Mr. McLean in the breakout with, I think he might be frozen. Can he go into the breakout with Kasha, if possible? All right, Ms. Vigilante, please proceed.
I apologize, Judge, if I may just shoot Ms. Jones a text really quick. I thought she was with us here today. And we did have a long talk yesterday. I just want to make sure she's not having a tech issue.
Okay.
That's who you wanted to break out room?
It's supposed to be Mr. McLean's cell phone, and I think he's standing with the person who needed to be interviewed, and Kasha, social worker. Mr. McLean might be gone. He was there a minute ago. It was frozen.
Yeah, I was looking for his cell phone. I don't see it.
It was on a moment ago.
He dropped off the screen, but
Okay.
Okay.
That's okay.
Kasha's gonna call 2391 and he's sitting at 2391. He'll receive a
Okay.
phone.
That's fine. Thank you.
Thank you.
Judge, I can share the basis for this plea being non-negotiated this morning while we're waiting for Ms. Jones to join us.
All right. We'll give her a few moments, but go ahead, please do.
Yeah, so our request is based on a long talk I had with Ms. Andrea Jones, and as well as, of course, my discussions with Mr. Anderson. She would like Mr. Anderson to be allowed to return to their shared home and for them to continue their relationship. When I explained to her the Family Violence Intervention Program, she thought that was a great idea. She was excited for it. She also did take partial responsibility for these incidents and told me that she is voluntarily enrolling herself in anger management because she wants to work on her relationship with Mr. Anderson. She really wants them to relate to each other in healthier ways. As I said, she should be joining us, and so that is the primary reason for her requesting an amendment to no violent contact and lifting the stay away per her request. Mr. Anderson does have a hold in DeKalb, and so we're also requesting a reduction of the jail time from 90 days to 60 days because he has already been here for a month, which, as we know, for financial reasons can be a significant financial strain. He is eager to resolve this DeKalb hold and get back to work. So he still will have a bit more time in custody as he will have to resolve an issue in DeKalb. He does work. He's been doing the same kind of work for over 20 years. He does tent setup and event setup for particularly for equestrian events. And so this is the busy season for that. And so he's looking to resolve that DeKalb issue and get back to work. I'm not sure. She said she's having some difficulty. She is trying to zoom in. She's having a bit of difficulty. She is texting me right now.
She has about 2 minutes, but I'll be honest, Ms. Vigilante, I'm inclined to accept the state's recommendation as it pertains to their contact because of the information before me. However, the court does not object to that 60 days. I will hear from her if she's able to come on, but in light of those, I would give him the 60 days so that he could go to DeKalb, but I would accept the state's recommendation as to the contact. So does your client wish to go forward with the plea?
Understood, Judge. Ms. Jones is just texting me, asking me to let you know she's still having technical difficulties and she would like to come before you and speak this morning. I think I would have to check in with Mr. Anderson privately for just a minute to see if he'd still like to move forward if it involves no contact with Ms. Jones and leaving his home. Your 1302 address, Mr. Anderson.
Okay. So if you'd like to ask him, and then is Ms. Jones on the line?
She just sent me a text this very minute that she's still working on it.
Okay, well, why don't you check with your client very quickly and see if he still wants to take the plea.
Okay, Your Honor, I'm joining Zoom from my cell phone, and to Mr. Anderson, I will, oh, she says she can't join Zoom. If she can't join Zoom, is there another way she can speak with you? I'm not sure how to tell.
No, she has to, there's no other way.
Okay. Okay, Okay, Mr. Anderson, I'm joining Zoom right now and we'll speak privately for just a minute, okay?
All right, just in the meantime, while we're holding for Anderson, does Mr. McLean have a position? Or do we have an announcement for Mr. Trivedi? Mr. Trivedi?
Good morning, Your Honor.
Good morning.
I had, the state and I, she presented a plea offer. I was speaking, I had some questions for her. I mean, depending on what the answer is to those questions.
Right. I did see your questions. I'm not agreeable to reducing it to a reckless. But I will, so I think the best course of action at this point is just to reset further notice. And you can address that with the trial court.
Okay, and Your Honor, I have spoken to my client about this. I don't know how the court wants the best way to handle this. At this point, I would need to withdraw and recommend Mr. Jafar that they get public defender services. Is that just a motion I would file? And is there an application he can fill out, or is that something that would happen?
Here's what I'm gonna ask that you do. If you'll enter a formal waiver of arraignment in this case, as well as your withdrawal motion, I'll sign those so that it can be sent to a division judge's courtroom, and from there he can seek other counsel. Okay? So
I can do
file
that.
both of those today so that at least his case is moving along the track.
Okay.
Right?
I
So
can do
we're
that.
gonna reset the case, further notice. Sir, your attorney is gonna withdraw from this case since he's indicated he doesn't do this work anymore. And you'll need to seek either the public defender's assistance here, or you can get another private attorney, okay? And I will sign, if you'll send your order today, Mr. Trivedi, if you can, I'll go ahead and sign your withdrawal motion. If you, Ms. Lewis, will you chat him your email so he can send that, and I'll sign it so we can move on with this matter.
Yeah, I can do that.
Thank you. All right, Mr.
Thank you, Your Honor.
Trivedi, does that conclude your business today?
Thank you, ma'am.
All right, take care. Have a good afternoon.
Oh, yes, that does conclude my business. Thank you.
All right, take care. Bye-bye. All right, is there another position we can go to at either courtroom 2 or ACDC?
Yeah, and I got two of Miss Maureen McLeod's clients inside courtroom too. We just
Okay,
wait
Ms. McLeod, you
wait
here?
for her to
still?
log back on. She needs to log back on. Thank you. Perfect. We're gonna go ahead.
Forward with Mr. Montez Williams now.
Whoops, I had to say it. That was it.
This is what, position 40 and 41?
Yes,
Okay, that's the one. And he did speak with the social worker.
Yes,
All right.
Your
The announcement then, Mr. McLean?
I believe that's was that an unnegotiated or negotiated plea, sir? You recall? Oh, I wrote it down. All right, let's see. If the state would remind me, I've got the paper over here, but if the state would remind me of the offer, I can say whether it's negotiated or unnegotiated as soon as I hear it again.
Okay, so the offer on positions, is that 41, Your Honor?
40 and 41.
40 and 41.
FTA.
Right.
40, the criminal trespass, it's 12 months served, 60 days, credit for time served, 16 days. That's 11/27 to 11/29, 2023, and May 3rd, 2024 to today. Balance probated, stay away from Hank Aaron Drive, Southeast in Atlanta, Georgia, which is the GSU Park Stadium. No further contact with Randy Lee Gale, MHET, and restitution stay open for 30 days.
Okay, Mr. McLean, was that the offer that you wish to accept? Is that negotiated?
That was going to be unnegotiated because the 14 extra days being the only issue that he'd like to argue against, and we'll state the reasons why.
Okay, before we go forward, Ms. Tyson, are you ready to give me that history?
Your Honor, I can't pull up his history for some reason. The document won't work. I'm sorry.
All right, Ms. Falk, do you have it?
Yes, Your Honor. The history is, let me just look at this real quick. The defendant has a total of, let's see, 48 cycles. His most recent is a May 3rd, 2024 probation violation on a felony case out of Fulton County. That's 18 SC 163475. He also had a probation violation for felony case 22 SC 182345. He has convictions back in 2022 of this year for theft by taking, criminal damage to property, and fleeing and eluding a police officer. That's on the 18 SC case. He also has a conviction for, let's see, he also has that 22 SC conviction, as well as a conviction for theft by shoplifting, which he was given 10 serve 3. That was in 2019, as well as multiple theft by shoplifting, driving without a license. He had a 2017 theft by shoplifting charge. And his history, like I said, is 48 cycles. That just gets us through the last 5 years. As to the 22 SC case, just take a look at that one that he's currently on probation for. Let's see. It looks like that one may have stemmed from an inmate offense, but let me just double check. Okay, that one seems to have stemmed from a theft by receiving stolen property, attempting to misrepresent tag, and marijuana less than an ounce. So that was that offense. He also has a recent case. It looks like that one was, he was found guilty of criminal attempt to commit a felony. That was November 14th of 2023. It did not show up on his GCIC, but it is in the clerk's record. He received 14 months commuted to time served on that case. And so that's kind of a background as to his history, which is why the state made our recommendation. As for this instant offense, this incident happened November 27th of 2023 at the Georgia State University Center Park Stadium. At that time, the defendant was sitting in a chair with a blanket over his head, and he had, it appears that he damaged the property of a vehicle on that site, which belonged to Randy Lee Gale. He also had broken a sign. He also stated to the officers when they tried to take him into custody, what would they do if he tried to break this Georgia State University sign? What he essentially did in our case is he approached the 2022 pickup truck belonging to Randy Lee Gale, balled up his fist, and punched the driver's side window of the truck, breaking it. That's all for the state.
All right, Mr. McLean.
Your Honor, the incident may involve a lack of medications on that day, but, you know, he would like to go forward with the plea. The social worker has cleared that for his being able to do that. He understands what we're talking about. The reason he would like to not do the 14 extra days is his mother, and I've not been able to confirm this anyway, because, you know, with the speed of SAP, you know, I met him yesterday. But he tells me his mother has stage 4 cancer, that she's actually in a hospital, and he would like to go home. That's in Columbus, Georgia. So he would still be in the state, he'd still be able to report and do anything he needs to do on probation.
Let me think. And you didn't object to the MHET?
No, Your Honor, that would be appropriate. The MHET is called for.
All right, I will accept the defense's recommendation. I'm sorry, it would be credit for time served 30 days. Is that what you're asking for, Mr. McLean?
Yes, Your Honor, or either that or just simply adjust the serve time to match what we have showing for a credit for time served.
What's the easiest way to do it, Ms. Lewis, so that it doesn't result in any typos? He served 16 days. Should we make it 32 days?
That's fine.
Okay. All right. I'm going to ask you some questions, Mr. Williams, to make sure that it's a voluntary plea. Please raise your right hand. Do you swear in the firm testimony again today be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And do you understand that you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand that you're giving up the right to make the state prove these charges against you beyond a reasonable doubt?
Ma'am.
And you understand the requirements? No contact with Mr. Gale and stay away from that location?
Yes, ma'am.
All right, as to the charge of criminal trespass and damage to property, how do you plead?
Guilty, ma'am.
I accept your guilty plea. Let's sound for Randy Gale, though. Is Mr. Randy Gale present? All right. Best of luck to you, Mr. Williams. That concludes your case. Is there anything additional, Ms. Falk? Or
Ma'am.
Mr. Not you, Mr. Williams, Mr. McLean or Ms. Falk, anything additional?
Nothing further, Your Honor. Thank you.
I just want to make clear the restitution to stay open for 30 days.
Are we still doing the restitution portion? All right, Ms. Falk says yes. Mr.
Say
McLean
yes.
does not object.
Understood. Well, I'll explain that further to him to make sure.
Okay.
You have to stay in the bench, please.
All right. All right, that concludes that matter. Who do we have next?
You got somebody else? Anybody else is from McLeod again? Oh, okay. That's for Mr. Thomas Henry. Are you ready for that? Section 28. No, I haven't. I've got to. Well, I took the photographs. I have to get them.
Your Honor, we're just waiting for Ms. McLeod to log on.
Okay. She was here.
Yeah, she had to go to another court today.
Okay. Are there no other positions we can take in the meantime? Okay, I guess there's nothing we can do. Ms. McLeod will be back, so I guess we'll be on a very brief hold.
Your Honor, if you're ready, we're ready with Mr. Anderson, position, I believe it's 2 and 3.
Yeah.
I'm sorry, I'm ready. What positions?
This is position 2 and 3, Mr. Ronald Anderson.
Okay.
Judge, did Ms. Jones ever make it onto Zoom to speak with you?
She did not.
I know even yesterday, her phone, she was having technical issues, so it seems that that's what's happening here.
All right.
We were wondering, Your Honor, if you would consider, I completely understand your concerns about, Ms. Jones and Mr. Anderson remaining together. He does have a stable place to stay that is not with Ms. Jones. And we were wondering if you would be willing to consider a modification of no contact to no violent contact upon completion of the Family Violence Intervention Program. So that's the 24-week class, and if he completes that and is successful, if you would consider a no violent contact with Ms. Jones.
I'm just thinking about the monitoring of that. Mr. Graham, the state's position regarding that?
Your Honor, the state's position remains the same. The state's concern is that this is a reoccurring situation between the two of them, and no further contact is our recommendation.
Right, I'm inclined to agree with that as well, Ms. Vigilante. Does he wish to still take this plea?
Yes, Your Honor.
All right. Ms. Anderson, please raise your right hand. Do you swear and affirm testimony given today will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
I didn't hear you, ma'am.
Are you under the influence of any drugs or alcohol?
No, ma'am. No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Do you understand that by taking a plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand the requirements of the sentence, that you have a course to take, you're to have no contact with Ms. Jones, and you must stay away from that location?
Yes, ma'am.
You further understand, and you also have your community service. You understand that as well?
Yes, ma'am.
All right, and you understand the other that you should not have additional time to serve at the Fulton County Jail under these requirements. All right. As to the charges of simple battery and battery family violence, how do you plead?
I plead guilty, ma'am.
I accept your guilty plea. Is there anything additional from the state or the defense?
No, Your Honor.
Nothing further from the state, Your Honor.
All right. Best of luck to you, sir. That concludes your case.
Does this consider a non-negotiated plea or negotiated?
It was non-negotiated. I accepted the defenses. I said 60 days.
Oh, so it's 60 days to serve?
Uh-huh.
Okay.
And Mr. Anderson, you get double credit here, so your 30 days fulfills your jail time.
Thank you.
Thank you for clarifying that.
All right. Who do we have next?
We have positions 44 and 45, Mr. Wright.
All right, Mr. Wright, your case number is 20, you have 2. Was it 3? This is Dontavius Wright, correct?
This is William Wright.
Oh, William Wright is okay. All right, Mr. Wright, your case is 23 CR 0052005F, in which you I'm sorry, 22 CR, in which you're charged with simple battery family violence, and then 24 CR, which is 24, which is just an FTA. You understand your rights today? Is that a yes?
Yes, ma'am.
All right, thank you. And the announcement for this case, Mr. McLean?
Yeah, this is number 4243. He has other things holding him, and I do have to consult with another attorney, the felony attorney, before I move forward. I understand what the plea is, and I do have to get the permission of that other attorney to say yes.
Okay. So you're asking for what, a reset, or what are we asking for, Mr. McLean?
1 week's fine, and it will not affect him.
All right. So your attorney has requested a 1-week reset of your case, Mr. Wright. So your case will be back on next Thursday's calendar. All right, that concludes your case for today, all right? Best of luck to you, Mr. Wright.
All right, we're gonna do positions 8 and 9 next, we're gonna get Mr. Davis right now.
Oh, and Ms. Fall,
Okay.
Yes.
I texted as a DM, a direct message to cell phone on those 2 citation yellow things.
Okay, I will check that in just a moment.
They're hard to read, and I understand y'all's argument, and I'm making a slightly different argument.
I understand. Thank you so much, PD McLean.
Thank you.
Hello, sir. Good, how you doing? We have positions 8 and 9, Mr. Davis.
All right, Mr. Davis, good morning. Your case is 24 CR 00017J. You're charged with criminal trespass and possession and use of drug-related objects. You also have an FTA. You have a right to remain silent. You have a right to an attorney, and this proceeding is being broadcast over the internet. You understand your rights today?
Yes.
All right. The announcement. Is there an announcement?
I apologize, Judge. This is Mr. Davis. He would like to enter a negotiated plea this morning.
Okay, thank you. I'm sorry, Mr. Graham, please proceed.
Thank you, Your Honor. The state's recommendation in this case on count 1, 12 months, served 34 days, credit for time served 17 days. That includes a period from January 1st through January 3rd, 2024, and May 8th through today. Balance probated, a stay away from MARTA in compliance with his ban. Count 2, 12 months, concurrent to count 1, balance probated in ADET. So total would be 12 months, served 34 days, credit for time served 17 days, balance probated, ADET, stay away from MARTA in compliance with the ban.
All right, Ms. Vigiletti, was that your understanding of the offer, and do you stipulate to the 3 elements?
We do so stipulate, that was my understanding. I did want to ask you, Judge, Mr. Davis has been homeless up until arriving at the jail. His intention is to go directly to either Gateway or Salvation Army for rehabilitation and housing upon his release. But of course, that will delay his ability to find work. So I was just wanted to ask you, Your Honor, if you'd be willing to assist him with probation to be here this morning.
All right, I will waive 2 months of fees. And once he's undergone the evaluation, it can go now reporting.
Okay, thank you, Judge.
All right. All right, let's, Mr. Davis, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes.
Did anyone force you to take a plea?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand by taking the plea, you're giving up your right to trial by judge or jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you further understand the requirements of the sentence as explained to you by your attorney?
Yes.
All right. As to the charges I previously listed, Mr. Davis, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional?
Yeah, Judge, briefly, if I may, Mr. Davis has a hold in Doraville, and I did find out what that hold was for. If I may put it in the chat, and Jail Court's iPhone, can you tell him what this hold is for if I send that info over to you in the chat?
I'm sorry, can you repeat that?
Yeah, if I send you just some information on his hold in the chat, will you just relay that information to him?
Okay.
Okay, thank you.
Yeah.
All right. Best of luck to you, Mr. Davis. That concludes your case.
Stay right now. Next, we have on the add-on, calendar, position number 2, Mr. Ingram.
Okay, give me one moment. All right. All right, good morning, Mr. Ingram. Your case is 24 CR 002172D. You're charged with simple battery, theft by shoplifting, disorderly conduct, obstruction, and criminal trespass. You understand? Oh, you have a right to remain silent. You have a right to an attorney, and I'm conducting this hearing over the internet today. Do you understand your rights?
Yeah.
Is that a yes? All right. The announcement, Ms. Vigilante?
Yes, Judge, this is a bond request, and I am wondering, because this does involve sensitive MH issues, if we could possibly discuss this in a breakout room. Ms. Fox, this is the case I sent you an email about.
Right, I see.
Is here as well. We have also been working with Kasha, the social worker who is here, and have done some consulting with Mr. Bartels as well.
Okay, we can go into a breakout, but before we do, what is the announcement? Does he intend to take a plea today?
No, Judge, we're making a bond request this morning.
Oh, okay. All right, so we'll hear the bond request in the breakout session. If I could go into a breakout with Ms. Falk. I don't really, courtroom 2 is that it's no point if you're not on another device, Ms. Vigilante.
I apologize. I can I'll join from my phone.
Okay. And there was a witness you said that needs to be placed?
His brother David is here as a representative of his family. I believe his sister Shanika is also here.
Is he a victim? Are either of those the victims alleged in this case?
They are not, Your Honor.
Okay, so they don't need to go into the breakout at this time. All right, so it'll be me, Ms. Vigilante, Ms. Falk. Is there anyone else that needs to join us?
And is Kasha still here with us, our social worker?
I don't see her.
Okay. Well, if she's not here, then just us for a moment.
Okay.
It's a breakdown.
Yep, have like a little private meeting, just read a change. Just-
Probation.
That's it.
What kind of probation that is?
What else for the other?
Shanika, you can hear me? You can hear me, bud?
Tell them that.
Hey, how y'all doing?
Probation.
I can't let y'all know this is still a court hearing. This is not a family gathering.
That's all she put on that probation violation in the chat. That's all she put.
She mentioned about doorbell, right?
I'm in court right now. You don't have to go about me now.
Let me know. I can't hear you.
Tell them to unmute.
On you.
Unmute.
Everybody's on mute. No one is talking at the moment. The judge is gonna break up.
Don't report me for 3.
Unmute yourself. Unmute.
Why you ain't called us?
I ain't got no booking number.
So report.
Okay, listen, I'm only gonna say this one last time. So I'm gonna remove you from
It's
this
my
court
fault,
hearing.
but you don't want.
This is still a court hearing. It's not a family meeting. So everyone needs to be on mute until the judge is ready to start the court back. So, sir, they will talk to you once the judge allows them to talk to you.
Ms. Tyson, are you able to confirm for us the history for add-on to Mr. Ingram? We just want to confirm his history.
The add-on number 2.
Yes, last name Ingram.
About 20.
This appears to be his only cycle out of the state of Georgia. And let's see, one more. He does have some history out of Illinois. Give me 1 second. Yeah. He has 12 cycles out of this. Yep, 12 cycles out of Illinois. 1 misdemeanor conviction for retail theft, and his last arrest was in 2009, and it looks like it was for, it just says issuance of warrant. It doesn't give me any other information, but that was from 2009, Your Honor.
Okay.
State has no objection to our $3,500 signature bond, Your Honor.
Right. I was assuming that in light of the age. All right. Defendant, we're going to convert the surety bond that defendant currently has to a signature bond with the condition that he will be released to his brother, Mr. last name Ingram, Mr. David Ingram. We do need the sound for both alleged victims in this case. Is Mr. Houlihan present? Wishes to make any statements? And I'm sorry, was it as Brooks, Ms. Falk?
Also Brooks.
Also
Ms.
Brooks.
Also Brooks.
Is that party present and wishes to make a statement? Okay. All right. I believe that we have addressed this matter and the signature bond will issue as discussed in breakout. All right. Best of luck to you, Mr. Ingram. That concludes your case at this time. All right.
Your Honor, with Mr. Jafra Zeta, it looks like he's still here on the Zoom, and that case has been further noticed for court.
I informed that to him on the
Yes,
chat.
and his attorney told him he could leave as well.
Nope.
I think he's enjoying staying with us.
He's more than welcome to stick around. I just wanted to make sure he was aware.
All right, Mr. Jafra Zeta, we're going to tell you one more time, you are free to go. But if you wish to remain, you are free to do that as well. Mr. Ingram, Mr. David Ingram, that your brother's case has been resolved, so you are free to go as well. And please feel free to come up to Ms. Vigilante with additional questions. All right?
All right, thank you so much.
Take care. Have a good day.
Excuse me, Your Honor, I have
Yeah.
a question.
Yes.
At 11, I'm going to leave out. I have Miss Jones, Samara Jones, for the 11 o'clock competency calendar. I'm going to step away. I'll have to log off at 11, and I'll be back.
Okay, let me make sure. Do we know if we need, who's the public defender covering the competency calendar?
Good morning, Judge. How are you?
Good morning, Mr. Bartels. Do you need Ms. Jones to be brought, or
Well,
can
it's
we
not-
discuss her case without her?
It's not critical that she be brought, Your Honor. She was requesting to speak to the court. If she could do that, that might give people, more of an idea of her situation, but it's not critical that she be here.
Okay, so do your best if she can.
I have already,
Okay,
so I will be back.
okay, that's fine. Thank
All
you.
right, thank you.
Oh, it is almost 11 o'clock. My gracious. All right.
We can go back to position number 28, Mr. Thomas Henry.
Okay. And I know we took a pause. We were waiting for, we were trying to figure out the time. Ms. Falk, has the state changed their position regarding the time he was booked in?
Your Honor, after reviewing the the citation, yes, he would receive credit for time served from, it looks like, the date of this incident, which was, let me just scroll down.
The 14th.
Looks like that would have been from April 15th of 2024 to today.
Okay, so how much, I'm really bad at math. Help me out. How much time has he served and how much? That would be no additional time then.
Well, no, actually it'd still be additional time, because it would be 32 days. So he would have only served about 32 days in jail at most. And we're asking for 90.
Okay. So if I accept the state's recommendation, Mr. McLean, and he has that additional jail time to serve, does he still want to take the plea today?
That is what he's wondering about, Your Honor. We've so far put up a non-negotiated plea. Do you want to stick with a non-negotiated plea, or are you asking for a signature bond? If you ask for a signature bond, that involves withdrawing your plea. And you would have an open case. You would have to see about that open case in the future, watching your mail like a hawk, making sure you didn't miss court, checking with the clerk to make sure you didn't miss court, and then have a trial in the future.
One question, the calculation is how many additional days would it be?
With the yellow tickets, I was arguing for 15, and he would like it to be 0, and he has basically heard the state's argument on that. So he would make the point that he believes that he's got the point about how many days he's been already, and the additional jail time would not be necessary for his rehabilitation.
And Your Honor, I just wanted to refresh your recollection about his lengthy history, as well as the severe injuries to this victim's face. Her eyes were swollen shut. She had marks on her neck, and a witness observed him punching her in the back of the head, which is also what led to the police being called out to that location.
Okay, I am inclined to accept the state's recommendation and require the additional days. However, we will accept that he had served the 32 days. Does your client still wish to take the plea, Mr. McLean?
So with 30, that would be, you'd be here another
About 2 weeks, a little bit more.
something like 13 days, I believe.
My math is shaky, but I have 15. No. You're correct, Mr. McLean, 13.
All right, so 13 extra days in jail if you stick by your plea at this point. But then the disadvantage is you'd have a conviction.
Why don't you mute it so that we don't all hear his? Okay, give us a mute. Just a brief mute.
Judge, I got a question. The concern is going to be the jail calculating this time. They gotta have proof of it. Even if I put it down, I can't guarantee they're gonna honor it because.
Oh, that's true. Well, Mr. McLean is there and can submit the.
I'm just putting y'all on notice. Just letting you know.
If it's not on Odyssey's sheet,
No,
then
it's not on Odyssey, and that's what I'm saying. It's.
there's no way to change it. Mr. McLean could go to records room while he's there and try.
Records gonna say, well, how you get this other time? Because if not, they're gonna calculate that 15 days.
Well, the other thing he could do is pull the jail time from ACDC and bring it to the records department at the jail. I mean, they're not all part of the same facility, but I mean, it's right down the street. So
yeah, I'll make note on it that he was arrested held in ACDC, check records for time. I'll make that note on the counter, but that's gonna be up to the jail, because they're gonna ask. Like I said, they're gonna ask for proof. They're gonna
I completely understand, and I believe that burden of proof is on the PD's office and to provide that on behalf of their clients.
And if we could maybe stick that little, Mr. McLean is gone. I was going to tell him to file it into the case, that citation his client had. That's helpful. Okay. Are we gone? Is this Mr. Thomas? Is Mr. Thomas back?
He's in the back, Your Honor.
Oh, okay.
Your Honor, he'd like for me to get his mom to Zoom on as well. Your Honor, because either one involves some extra days.
Is his mother the victim?
No, Your Honor.
Okay, so I'm not sure.
I asked for a 1-week reset and have his mom on Zoom next week.
What is his mom gonna add, Mr. McLean? It's typically the victim would be the one speaking out. Is his mom just gonna tell us? What is his mother gonna tell us?
That he takes care of her.
Okay, we're not gonna reset for that. Either he's gonna take the plea today, Mr. McLean, or we're gonna reset him for the notice to the division judge and address bond. So which one does your client want to do?
I'll explain that choice to him.
Okay, because yeah, that's not persuasive evidence today.
Judge, you gave him $100 cash bond on this.
Say that again. I'm sorry, Ms. Lewis, I couldn't hear you.
You gave him $100 cash bond on this case, on the.
I
SEC.
did?
Yes.
I gave a cash bond?
Yep, $100 cash bond.
Probably due to his lengthy history and the violent injuries toward the
Yeah.
victim.
Usually that's not like, that's not
Yeah,
typical.
you said $100 cash bond on the SEA counter back on May the 3rd for him.
Really?
Mm-hmm.
That's not my flavor usually. Okay.
It was just $100
You
cash.
sure that was me?
Uh-huh.
Okay. Hmm.
Yes, ma'am.
What kind of day was I having? All right.
I think Judge Williams, you were persuaded by the powerful arguments presented by the
I must have been really moved because like
I'm looking right at it, May the 3rd, your signature.
I believe that cash bond is just unusual for me.
You gave him $100.
All right. All right. Who do we have before us? And I see Ms. McLeod is online. Good morning, Ms. McLeod.
I was trying to put a client on now. This is gonna be the add-on 5, Mr. Tyrone Watley.
And this is Ms. McLeod's client?
That is correct.
Thank you. All right, Ms. McLeod, are you here? Good morning.
Good morning, Your Honor.
How are you today? Have
I
you
am
spoken
very
with your
well, thank
client?
you for asking.
You've spoken with your client and ready to give me an announcement for this position?
Yes, Your Honor. Which one of my clients is this?
This is position 5, Mr. Watley.
Oh, yes. I have spoken with Mr. Watley, and this is going to be a plea, Your Honor.
Okay. Mr. Watley, your case is 24 CR 002416G. You are charged with theft by receiving stolen property. Do you understand your rights this morning?
Yes, ma'am.
All right, Ms. Falk, will you put the recommendation onto the record? You're muted.
Yes, Your Honor. On this case, the state's recommendation is going to be 12 months served 60 days. Credit for time served 19 days. That's going to be from April 28th, 2024 to today. No further contact with Corey Wood. Stay away from 1687 Campbellton Road Southwest. An anti-theft course and 40 hours of community service. We would like to sound for Ms. Corey Wood, and we do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea.
We do so stipulate.
All right, is Ms. Woods present? Okay, I don't see anyone with that name. And that was your understanding of the offer, correct?
Yes, Your Honor, it is.
All right, Mr. Watley, please raise your right hand. I'm going to place you under oath for the limited purposes of taking a plea. Do you swear and affirm testimony you give today be the truth to the best of your knowledge and not under the penalty of perjury? All right, you're muted. Can we unmute him at courtroom 2? All right. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand by taking the plea that you are giving up your right to trial by judge or jury?
Yes, ma'am.
And you are satisfied with your attorney's representation?
Yes, ma'am.
And you understand the requirements?
Yes, ma'am.
All right, as to the charge of theft by receiving, how do you plead, Mr. Wiley?
Pretty good.
All right, is there anything additional, Ms. McLeod or Ms. Falk?
No, ma'am. Good.
Nothing further, Your Honor.
All right.
None from the state, Your Honor.
Judge, help me out if you can let me know if these cases are remain on probation or going on reporting, because
okay.
That helps me out a lot. If not, they're just gonna remain on probation.
I usually don't do anything unless the defense asks me. But
Yeah, I was going to ask Your Honor, I would ask Your Honor that once my client has completed the terms of his sentence, that is probation going on reporting.
All right, I have no objection to that. So it will go non-reporting once he's completed the requirements.
So I just want to be on the same course. If they don't ask, it's just they remain on probation. That's what it's gonna be. Okay. Just want to make sure.
As long as the defense attorneys ask me, I'm willing to entertain.
Okay.
But I'm not going. Okay.
All
right.
I'm with you. I'm with you. That's no problem.
All right, Mr. Wiley, best of luck to you.
Next, Your Honor, we're gonna go to add-on 3, Mr. Justin Johnson.
Okay,
Your Honor, let me announce on Henry Thomas, let's just do the not guilty, and he'll go ahead and make his bond.
okay. All right, so Mr. Thomas will be reset for the notice. Are you gonna do the enter of a formal waiver?
I'll sign a waiver.
All right, thank you, Mr. McLean.
I believe he's got $100 cash bond. Is that correct?
That's what I would just confirm, yes.
All right, thank you.
All right, best of luck to you. All right, we're on add-on 3. Get it. Mr. Johnson, your case is 24 CR 002391E. Do you understand your rights today?
Yes.
All right. And the announcement, Ms. McLeod?
Yes, Your Honor, this is going to be a negotiated play as well.
All right, Ms. Paul, please proceed.
Yes, Your Honor. The state's recommendation on this is 12 months served 34 days, credit for time served 19 days. That's going to be from April 28, 2024 until today. Balance probated, 8 weeks anger management, no further violent contact with Christian Johnson, KHRISTIAN. Stay away from 675 Hanley Avenue, Southwest Atlanta. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. And we would like to sound for Mr. Christian Johnson at this time.
All right, is Mr. Johnson present? All right, I'm sorry, Ms. McLeod, please stipulate.
Yes, the defense does stipulate, Your Honor.
And that was your understanding of the offer?
It is, Your Honor.
All right, sir, please raise your right hand so I can place you under oath. Do you swear and affirm the testimony you give today will be the truth to the, lost my thought. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
You understand that taking the plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand that you're giving up the right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand the requirements?
Yes.
All right. As to the charge previously listed, Mr. Johnson, how do you plead?
Yes.
I accept your guilty plea. Anything from state or defense?
Nothing further, Your Honor.
All right, Ms. McLeod, any requests?
Well, I don't believe he's on probation.
I just want to make sure. Okay. All right. All right. Best of luck to you, sir. That concludes your case.
Okay, thank you.
All right. Is that your only clients today, Ms. McLeod?
I do have one other, Your Honor, but I have been unable to speak with him. It's Mr. Edmonds. I've been told he's on the floor.
He was released. You talking about Mr. Dante Edmond?
Yes, okay.
Yeah, he made bond. He was released.
Awesome, good. Well, that concludes my business before the court today. I will get the plea paperwork over to you, Ms. Lewis.
Thank you.
Real quick on Justin Johnson, that was balance probated.
Oh.
Yeah, that's what I thought.
Well, Your Honor, may I ask?
Just wanted to make sure everybody was on the same page.
I guess I'm not, to this morning, I'm not functioning as I probably ought to be. Your Honor, I would ask that once he has completed the conditions of his sentence, if his probation could be suspended, or at least go non-reporting.
State doesn't object to non-reporting.
Yeah, it can go non-reporting. I when it's not written on the calendar, I struggle as well as to what it is. So, all right, yes. All right, Ms. McLeod, take care. Have a great afternoon. Bye-bye.
Thank you. You do the same. Yes, so I will send the paperwork over to you, Ms. Lewis.
Thank you.
You're welcome.
All right, who do we have at jail court, Eiffel?
We have our positions number 21 through 24, Mr. Kenneth Back.
Your Honor, that's a plea.
21 through 24. Okay. This is Mr. Pack. Mr. Pack, you have several cases today. Your cases are 23 CR 006577C, in which you're charged with criminal trespass. 23 CR 006878C, in which you're charged with criminal trespass and simple battery against an officer. 24 CR 000040C, in which you're charged with criminal trespass and committing certain acts in a rail or bus station, and 24 CR 0002251C, in which you're charged with criminal trespass, obstruction, and a charge that won't sound, as well as certain acts in a bus station. Do you understand your rights?
Yes.
All right, and this is going to be a plea today. Mr. Graham, if you would put a brief factual basis onto the record, as well as your recommendation.
Your Honor, this is actually my case.
Oh, I'm sorry, Mr. Graham was on. He doesn't join us usually when he's speaking. Ms. Falk, please proceed.
Position 21, the criminal trespass is 12 months served, 8 days, credit for time served, 4 days. That's going to be from 10/21 to 10/24/2023. Balance suspended. Stay away from all MARTA stations in compliance with a lifetime ban. On position 22, it's going to be 12 months concurrent on the criminal trespass, 12 months concurrent with count 2. On count 2, 12 months served, 60 days. Credit for time served, 5 days. That's going to be from 11/3 to 11/8 of 2023. That is going to also be a balance probated. Stay away from all MARTA, 12 weeks anger management. Position 23, count 1, criminal trespass, 12 months served, 6 days. Credit for time served, 3 days. That's going to be from January 2nd to January 4th of 2024. Balance probated. Stay away from all MARTA stations. Count 2, 12 months probation concurrent with count 1. Position number 24, the criminal trespass, count 1, 12 months served, 30 days, credit for time served, 21 days. That's going to be from April 24th, 2024 until today. Balance probated. Stay away from all MARTA. Count 2, 12 months concurrent to count 1 with the $300 fine. Count 3 and 4, 12 months probation concurrent to count 1. We would ask the defense to stipulate to venue factual basis and identification for the purposes of this global plea.
For the purpose of the plea, we do so stipulate. So as I understand the global situation, the controlling factor on any extra days would be number 22 with a recommendation of 12 to serve 60 with credit for 5. That will cause an additional 25 days?
That would be correct.
You understand that, Mr. Pat?
I would understand. What did you just say?
The math works out to an additional 25 days. You remember you were on the calendar the other day and we were in the middle of the plea. So 25 extra days would be the result. And then it would be balance probated because there's a $300 fine to be paid. So that requires a person's paying a fine, unless you need to do that as 30 hours of community service. Still, that would be probation. So you'd have to go to 132 Mitchell Street. Remember that discussion. Okay.
Do you want to take the plea today, Mr. Pack?
25 additional days in jail, then $300 fine.
On probation. And it's, I would have.
Got 12
25 days. So is the time to be served 25 days in jail?
Wait a minute. Do you want to call him, Mr. McLean? Can he call over there?
We're having this really loud noise from the alarm system.
Oh.
There's nobody in the courtroom. Does he need to go in a breakout room?
Yeah, can we do that? Can we put breakout?
Yeah, I'll put him in the breakout room.
That would be fine if they would just stop this alarm. It's really.
Oh, he has noise on his end in courtroom too. He says there's an alarm going off.
They want me to do 25 days a year on probation.
Do that breakout.
Okay, I'll put him in the breakout room. Tell him about this. I just want to make clear, Ms. Falk, position 21, that's a valid suspended sentence? 21?
Double check position 21.
Yeah, for him, for Mr. Pack, that's a suspended balance, right?
Yes.
Okay, and then the rest of them, 22 and so 23, is 23 a balance suspended too?
23 is balance suspended, 24 is balance probated, 22 is balance probated.
Okay, because I thought you said balance probated on 23, and I was trying to figure out what was the conditions on 23.
Right.
So it's balance suspended on 23 and 21. He just got to be on probation for 22 and 24.
That is correct.
Okay. And I think Mr. McLean probably forgot you got 12 weeks of English management class on 22 and the $300 fine on 24. Those are the two main conditions, I think, for probation. Judge, I know one of our DV counter participants is on the line, position number 2. You do have that counter, right? I can't hear you. She mute.
Judge Williams, you're on mute.
She said, hold 1 minute.
Sorry, civil calendar problem. Okay, we have the 11 o'clock DV reset. Let's see, let me pull that calendar. Good afternoon, Mr. Murphy. Are you here for that calendar?
I'm here for competency, 11 a.m.
Oh, okay. We haven't quite gotten to that yet, Mr. Murphy.
Then I'll come back.
All right, Mr. Diaz, are you represented by counsel today?
Yes, ma'am.
Who's your attorney?
Olivia.
Oh, Miss Vigilante. Okay, so we can't do anything with that anyway. Please hold. Thank you. $13 and $14 was released, right, Miss Lewis?
I can tell you in a minute. I can tell you who's been released. Position number 4 has been released. I think the state was going to give me a transfer to Superior Court on that case. His fault. Position number 4.
Still working on getting that for you, but
Okay,
yes,
well,
that
he's
is
out
the
of
goal.
jail.
But he's out of jail, so
He's out of jail, so it's just reset for notice. You'll just have to send a transfer order to the original judge. Position number 12 is out of jail. Position number 18 is reset. He's out of jail. Position number 20 is out of jail. Position 31 and 32 is out of jail. Position 35, 36, 37, 38, and 39 is out of jail. That's all I got. Who's out of jail? And I think the announcements. Based on what the PD is gonna give us.
I was trying to figure out if we could review the calendar at this point, but it doesn't seem like it. Too many. Still missing. All right, we'll be on a very brief hold.
Mr. Diaz, I'm gonna need you to turn off your camera if you're gonna be eating your food.
Me? Huh?
No, I'm talking to Mr. Diaz.
I don't.
All right, Mr. McLean, do you have an announcement? You're muted.
We're kind of stressed out. We had to go back to our cell, Your Honor. We'll have a social worker visit and that should be for another day.
Okay, so are we resetting 1 week or what are we doing with that?
That's fine. I hope, the social worker's schedule should accommodate. They'll see him by then.
That was Mr. Peck or Pack? That was Mr. Pack.
Pack, P-A-C-K.
And he had additional jail time anyway, so a 1 week reset will not prejudice.
That's
All right.
exactly right.
Okay, so that's position 21, 22, 23, and 24. All right. Are there other positions that can be brought? Is Ms. Vigilante there? Can we address the DV calendar?
What's this, what do we do on 19?
Nothing.
Nothing.
Judge,
I don't have anything for that one.
Okay.
You?
No, I don't. I think that's, still to be done.
Okay, I have 20 was released. Let's see, we're holding on 19. Let's see. What's the announcement for 6? It was 6 was released?
No.
So we're holding on 6.
no, Your Honor, Mr. Curry waives his presence and arraignment this morning.
Okay.
I'll file a waiver.
And so it's gonna be reset for the notice.
Yes, Your Honor.
Okay. 7, 8, 9. Do we have an announcement for, position 12 was released. 13, 14 was released. Are we holding on 15? Abraham Harris?
Number 15, Your Honor, there is a series of not coming to the visitation booths. So I believe what I'm going to need to do is actually go with the deputy on the floor to go to the zone door because we've got to lay eyes on him.
Okay, so 1 week reset, so you can do that?
Yes, Your Honor, this is not the only reset we've had on that.
Yeah, and Judge, I will just add, I did go with the deputy to see him in person and he wouldn't speak to me and, was threatening me and screaming and shouting. So I highly doubt Mr. McLean is gonna have a different outcome.
Okay, so perhaps we do formal waiver of arraignment and reset division.
Well, but we have to see him again. There's a certain number of days. We got to just do a wellness check on him. I'm sure he's fine.
Okay. All right. Understood. 1 week reset then.
And
All right.
which position is this, Your Honor?
That
I'm sorry.
was 15, Mr. Harris.
Yeah, 15.
Harris. Okay, thank you.
So we'll reset him a week. Are we holding on 25?
25.
We have 25 right here in front of us. I'm sorry.
Okay. All right, that case is gonna be reset 1 week is the announcement I have. Is that still correct?
Mr. Brown,
25.
my name
Is that true, Ms. Falk, that you're seeking the case was transferred?
No,
Oh, no, it
we are
was. It's back. It's back to us.
correct.
Does the public defender's office still need a week to further develop this case?
Your Honor, let me.
No, it's the state who's asking for a week, Your Honor.
Oh, you're asking for a week.
Right. It was transferred down to from the
Oh.
DA's office and the aggravated stalking was dismissed. And for the life of us, we can't figure out why. So we need to reach out to the DA's office and get some clarification on this.
Okay, Mr. Price, there's some more development that needs to be done by both sides on your case. Your case is gonna be reset 1 week. At that time, we should have some clarity about what direction your case is going. Your attorney will make contact with you by then, okay?
Your Honor, he just. What his bond situation might be confused right now because right now he's only got a misdemeanor and he is entitled to a bond.
Does he have a bond?
I don't think so.
Okay. We can hear him on bond.
Let me go and pull up that Brandon Price. That is correct, Your Honor. He's being held currently without bond on that charge.
Okay.
I would just ask the court to consider whatever bond would be suitable. The charge is
Criminal trespass.
criminal trespass, 1 count. The state may have further information that it would.
Let's start with his history. Ms. Tyson, are you still here? Can I have Mr. Price's history?
Yes, Your Honor.
Thank you.
It's 27 cycles, beginning in 2007. He has a misdemeanor criminal trespass out of Cobb County. That's from 2013. He has a felony conviction out of Cobb County for burglary in the 1st degree. That's from 2013. He has another misdemeanor conviction out of Cobb County for theft by taking, willful obstruction, and obstructing or hindering persons making emergency telephone call. It's from 2014. He has another misdemeanor conviction out of Cobb County
Okay, so they.
for 2 counts of simple assault. That's from 2016.
And you haven't updated your address yet.
One moment.
Okay, so it's not that they didn't send it.
He has another misdemeanor conviction out of Cobb County for simple battery. That's from 2021.
So I'm just gonna.
Okay.
Let's see. And he has at least, let's see, 1, 2,
To Mr. Court.
3 FTAs and
Right away, and they didn't know, and so we don't want to information.
6 violations of probation, Your Honor.
Okay, thank you. Ms. Falk, the state's position regarding his bond?
Yes, Your Honor. This incident happened back in April 5th, 2024. Hina Ashkar was in a relationship, had been in a relationship for 3 years with Brandon Price, but they were at this point exes. The defendant came to her residence on Creole Lane, initiated a verbal dispute. She did not open the door because she was hopeful he would leave the residence. He began to start raging at her verbally after she denied him entry. He grew more and more upset. At that point, Ms. Ashkar called 911 and reported the aggressive verbal dispute. She stated she did not invite him, they did not have any prior communications, and it was clear his presence was unannounced. At that point, the defendant began destroying Ms. Ashkar's white in color Audi. He damaged the front windshield, the driver's windshield, and the left passenger side windshield, which were all destroyed. The defendant at that point left the residence on foot in an unknown direction. The police confirmed with Ms. Ashkar that there was an active TPO issued by Judge Glanville on February 20th of 2024, 24 CV 001899. So as you can understand, Your Honor, that is the reason the state is requesting a 1-week reset. Number one, the damage to her property, breaking the front windshield, the side windshield, and the driver's side windshield, the driver's side door of her car, the windows of all 3, the state finds it very hard to believe that's going to be less than $500 worth of damage. We don't feel any due diligence was done on this case to make that determination before it was transferred. Additionally, the aggravated stalking warrant appears to have been just somewhat summarily dismissed in felony court and sent down to state court with no further research or information provided. And so for that reason, we're going to ask for a $5,000 surety bond, stay away from Ms. Ashkar's residence at 1501 Creole Lane, no further contact with Hina Ashkar. That's HINA-ASGHAR. We are also well, that's all for the state at this time. But again, as Your Honor hears from the explanation of this offense, as well as his history, which includes burglary and multiple failure to appears and probation violations, that is what raised the state's concern about this case.
All right, Mr. McClain. Oh, let me sound for Ms. Hina Ashkar. All right, Mr. McClain.
Your Honor, I believe, because we simply rely upon the fact that it's 1 count of criminal trespass at this point, $1,000 surety bond would be probably the better course.
All right. Defendant will receive a $1,500 surety bond. He's to have no contact with Miss Ashgar and stay away from that location. Additionally, he's to have no drugs, no alcohol, no weapons as a condition. Is there anything additional?
Nothing.
All right. Best of luck to you, Mr. Price, and your case will still be reset a week. You do have a bond on this charge now at this time. All right. Who do we have next?
We have position number, before we continue, position number 1, Mr. Aluba, he said he has a private attorney.
Yes, I think we reset that case so that the attorney can do some work.
Okay.
His attorney is gonna make contact with him. His attorney did appear this morning and asked for time to do some diligence there. So his attorney will reach out to him and he's gonna be reset to all purpose on the 30th in the event that that's necessary. But more than likely, he'll be transferred and assigned to a judge.
Okay.
All right.
Right here, we have position number 19, Mr. Kendrick.
Very good. 19 is going to be fairly straightforward.
Is this what is this one, Mr. McLean?
It's a plea to time served, balance suspended, stay away from Georgia Tech property.
Okay. All right. Mr. Kendrick, your case is 24 CR 002690F. You're charged with loitering and prowling. Do you understand your rights today?
You know, it's
Yes, ma'am.
You have a right to remain silent. You have a right to an attorney, and I'm conducting this hearing over the internet. All right. Mr. Graham, please proceed.
Thank you, Your Honor. The state's recommendation in this case is 12 months to serve 32 days, credit for time served 16 days. As from May 1st until today, a balance probated, stay away from Georgia Tech property. And we ask the defense to stipulate to factual identification for purposes of the plea.
Yeah, I think it's suspended.
Do you so stipulate, Mr. McLean, and was that your understanding?
Yes, Your Honor, I didn't believe it's balance suspended.
Is it balance suspended? Or is it balance probated, Mr. Graham?
Your Honor, if I may just double check with Deputy Chief Falk. The calendar that I have has balance probated, but it may be a typo.
Well, there's nothing for probation to monitor.
Right. I guess maybe they're concerned about the stay away, perhaps, but let's just.
Okay. No, Your Honor, balance suspended.
Okay. All right, understood. All right, please raise your hand, Mr. Kendrick. I'm going to ask you some questions to make sure this is a voluntary plea. Do you swear and affirm testimony you give today will be the truth to the best of your knowledge under the penalty of perjury? You're going to tell the truth today?
I'm going to tell the truth today. Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
Can you say that one more time?
Are you under the influence of any drugs or any alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone promise you anything in exchange for taking a plea?
You did. My son said, I pay gifts, I go home.
All right, but did they give you any gifts, any money, anything like that, so you will take a plea?
No.
All right, do you feel forced to take this plea today?
Yes.
You feel for
No.
if you feel forced, I can't take the plea. Do you want to take a plea today?
Yes, ma'am.
And you understand you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you understand there'll be no further court dates?
Mm-hmm.
And you understand that taking a guilty plea can affect other aspects of your life, such as employment, immigration, or other things that I might not be able to anticipate. You understand that?
Yes.
All right, Mr. Kendrick, as to the charge of loitering and prowling, how do you plead? How do you plead? Do you plead guilty, not guilty? How do you plead to the charge of loitering? All right, I accept your guilty plea. And you further understand you can't go back to Georgia Tech, correct?
Yes, ma'am.
All right. Is there anything additional, Mr. Graham or Mr. McLean?
Nothing further, Your Honor.
All right. Best of luck to you, Mr. Kendrick. That concludes your case. If you have,
Uh,
I'm sorry.
No, I'm just explaining that. We have to go down to 3 North and grab Mr. Edwards.
Okay.
We know. Give it, Edward. Is there Edwards on Green North?
Yeah.
No. Do we have any update information on position 26 and 27?
I do not hold it.
Mr. McLean's case. I think those are only 2 I'm missing information on. Position 13.
I'm not seeing it.
They're gonna go and get Mr. Edwards, so position 13, 14 is gonna be taken care of once they get Mr. Edwards. So those are only 2 cases I don't have information on, 26 and 27.
Okay. Ms. Vigilante
Yes, Judge.
or Mr. McLean, are we holding on other positions or other, do you have an announcement for 26 and 27? Will they be brought to and addressed today, Mr. McLean?
Mr. McLean is on the phone. He has called ACDC a couple of times this morning trying to get in touch with Ms. Ray, and I believe he.
Okay. I have 36, 37 was released, 39, they're gone.
I see. Judge, the issue with Ms. Ray is that she's actually here at medical. That's why she's not been reachable.
Right, yesterday we were told she was at ACDC, but that was either correct at the time or incorrect at the time, but it's not correct today.
So I think
Okay.
we'll have to reset her typically when someone is here getting.
Okay, so we're gonna hold to see if Miss Ray can be brought. Is that what we're doing?
Is it possible to bring her from there?
What about 42? Miss Lewis, do we have enough for 42? Did you say 40? Are we holding on 42?
I thought 42 was reset to next week, 5/23.
That was 44 and 45. William Wright, Dontavius Wright.
Hold up, 40. There's so many rights on here.
It's right. 44, 45
Okay,
was.
I have 40 and 41 was a plea. I mean, 40, 41 took a plea. 42, I have SAP for 5/23. That's 42 and 43. That's Dontavius Wright. And then I have Williams Wright also reset another week.
Okay, so is that correct, Ms. Vigilante? Still, we're resetting 42 and 43?
I believe so, Your Honor.
Okay, so reset 1 week.
Yeah,
So we're just holding for Ms. Ray?
I believe
Yeah.
so. And Deputy Norris and Mr. McLean went to see if it's possible to speak to her right now.
Okay, can we in the meantime do the person on the DV reset calendar? Are we
yeah,
prepared to start that?
Yes.
Okay. I'm making sure we didn't miss anybody else.
Both defendants are on the line for the DV calendar.
Okay, so only on state of purpose, the only thing I have is Miss Ray.
And Mr. Edwards, they're gonna go and get him.
Okay. Okay, so holding on those 2 state of purpose positions, we're gonna shift gears and start the DV reset calendar. This is those individuals who may have an outstanding domestic violence bench warrant. We're gonna address the matters to see if the bench warrant should be cleared and the case reset, or whether the bench warrant will stand and the defendant will need to surrender themselves. I believe both parties are represented by counsel. Let's first see, is Mr. DeMontez Brown present? If you are, please activate your camera. All right, Mr. Brown, your case is 23 CR 001169C, in which you're charged with simple battery family violence. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel. As you can see, I'm conducting this hearing over the internet and it's being broadcast as a live stream. It's also being recorded. That means any member of the public can log on and watch. Do you understand your rights and how I'm conducting this hearing today?
Yes, ma'am.
All right. Ms. Falk?
Yes, Your Honor. Just to give Your Honor an overview, this case, the defendant failed to appear on April 26th of 2024. He made bond on March 8th of 2023. And then at that point, it looks like the warrant was issued and then he appeared on today's calendar. So I'm not sure what the basis, the explanation is for why he failed to appear. And I would believe that would need to come from the defendant.
All right, Ms. Vigilante.
Yes, Judge, I spoke with Mr. Brown this morning and there's just a bit of an unfortunate timing issue here. It seems the notice to appear was mailed out on March 11th, 2024. Very likely hit his mailbox a few days later. And Mr. Brown moved in March. And so has since updated his address with the court. It was certainly not his intention to be running from the court by any means. He and his mom moved together. His mom actually got a call from the bonding company asking why he missed court. They were both completely shocked. So he immediately called the clerk's office. He spoke with Ella Williams. She explained the process and he came in and updated his address. Mr. Brown, it's my understanding, and perhaps the state can verify, doesn't have a history of failing to appear. He certainly wants to resolve this case. He is on disability, I'm sorry, he doesn't receive disability income yet. He has recently been diagnosed with a disability, so he's not working, but he does have 2 children that he has up to 4 days a week, taking them to sports activities that he is responsible for. He also helps his mom with his 3 sisters. His oldest sister is 15. And so they definitely have a full house. He is an important caretaker in the household. And so I am asking Your Honor to set aside the bench warrant this morning, give him another chance. You know, moving is chaotic and we do have all of the correct information now. And he was, you know, proactive once he realized he missed court.
All right, sir. Go ahead.
My apologies, Your Honor. Just to correct PD Vigilante, the defendant actually does have a history of failure to appear. He had a failure to appear on March 3rd, 2023 out of the Gwinnett County Sheriff's Office, as well as a probation violation on that date.
Okay. All right. I do note that FTA, I will allow the defendant to surrender I'll set aside the bench warrant on this one occasion. Defendant is getting a second chance. Do not miss this next court date. Make sure your address stays current with the court. At this time, Ms. Brown, your case will be reset for the notice. Please make sure that you stay in contact with your attorney so that this does not happen again. You will not receive a second set aside. All right?
Yes, ma'am.
All right. Best of luck to you, Mr. Brown. You are free to go if Ms. Vigilante has your proper address.
Yes,
I
ma'am.
do. Thank you, Judge.
All right. Let's take up the next case on the DV warrant calendar. Carlos Diaz, 23 CR 002481F. The matter in this case, he's charged with battery, family violence. I'll allow Ms. Falk to begin, and then we'll hear from Ms. Vigilante regarding any excuse that the defendant may have in this case.
All right. So as for Mr. Diaz, it looks as though he failed to appear on, well, he actually failed to appear on 2 different occasions. So he failed to appear on February 20th of 2024. There was a reset because that was due to Cybergeddon. There was an outage due to Cybergeddon. So they reset the case. He then failed to appear on May 7th of 2024 on this case, at which point it was the bench warrant did issue for his potential arrest. I will say that this case was bound over from, municipal court back in April 19th of 2023. and was sent to our office based on that case. And so it looks like he had an unsecured judicial release on the case when it was in municipal court, and then it was bound over, at which point he failed to appear.
Ms. Vigilante?
Yes, Judge, this case is a little bit of a mystery to me because when I read Mr. Diaz, this 5105 Collingwood Lane address in Alpharetta, he has absolutely no idea what that address is. It's not his parents' address. It's not a place he's ever lived. It's not the address he says he gave the jail when he was brought over. It's not the address on his ID. I think it's possible that the address this notice went to is just completely an error. He's never lived in Alpharetta. I did look up the address. It is just apartment building in Alpharetta. I really can't say why his notices were going to this address. But what I can tell you is that he actually proactively called his bondsman because he thought it was unusual that he hadn't had a court date yet. He asked if there was a hearing. The bondsman said, "No, I don't see anything on the calendar, but here's the clerk's number. Give them a call." He tells me he called the clerk. He called the clerk, just so happened on May 7th, which was the day of his court date, and found out that he did have court that day. He drove a couple of hours to 160 Prior Street, which, as you know, is actually not the correct courthouse. The correct courthouse is 185 Central Ave. He waited about an hour and 45 minutes at 160 Prior before they realized that he was at the wrong courthouse and is actually supposed to be in another courtroom. Ran over to 185 Central Ave, and he had just missed court for the day. And so, you know, they did tell him he was going to have to go and reset the case. So he did do that just shortly after, you know, went to the clerk's office, updated his information. He did, you know, make every effort to be there once he realized he had court. We do have the correct address for him now, the correct phone number, correct email. When I reached out to him, he was very responsive across all forms of communication. So I don't expect we'll have further issues.
All right, Ms. Falk, any response?
None, Your Honor. I feel like that is actually a fairly sufficient response to why he did not appear in court, and we are not objecting to a lift of the bench.
Yeah, the court is inclined to agree. Please make sure that your address is current and correct, Mr. Diaz, so that we can avoid any future complications. I will set aside the bench warrant. Your case will be reset for the notice, and you know, please make sure that you are vigilant in checking on this. There have been some issues, and I don't want there to be another warrant out for your arrest because you've missed something else. All right?
Me neither. Thank you.
All right. Best of luck to you. That concludes the DV reset calendar. Are we ready to begin? We're still holding for Ms. Ray.
If I may briefly, Judge, I believe I saw at medical positions 13 and 14, Mr. Edwards.
Okay, can we take those positions up at who do we have at medical?
I believe I saw him. He was on the screen for just a moment. Positions 13 and 14, Mr. Edwards.
Is anyone at medical?
There he is.
13 and 14, Edwards.
All right, Mr. Edwards, your case is 22 CR 008260F. In this case, you're charged with theft by taking and loitering and prowling. You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney today. I'm conducting this hearing over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this. Do you understand your rights and how I'm conducting this hearing today?
Yes, ma'am.
All right, thank you. What is the announcement, Ms. Vigilante?
Mr. Edwards would like to enter a plea today, and so we just asked them on the recommendation of the state this morning.
I'm sorry, there was some interference for a moment. You asked that I accept it as negotiated, I'm assuming?
Yes, Your Honor.
All right, Mr. Graham, please proceed.
Thank you, Your Honor. State's recommendation on count 1, theft by taking, is 12 months, serve 133 days, credit for time served, 133 days. That's the period from November 8th, 2022 until March 11, 2023, and May 7, 2024 until today. Balance probated, an anti-theft course. no further contact with Leslie McClendon. Stay away from 1 Bell Street, Atlanta. On count 2 will be 12 months probation concurrent with count 1. I'd like to sound for the victim, Your Honor, Leslie McClendon, and ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
All right, is Leslie McClendon present and wishes to make a statement? Okay, hearing none. Do you so stipulate, Ms. Vigilante?
Yes, Your
And
Honor.
was that your understanding?
Yes, Your Honor.
All right, Ms. Edwards, please raise your right hand. I'm going to place you under oath for the purposes of taking the plea, okay? Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your head down. Are you under the influence of drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
And you understand by taking the plea, you'll have no further court dates regarding this charge?
Yes, ma'am.
And do you understand the requirements of the sentence?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment, immigration, or other things that I may not be able to anticipate?
Yes, ma'am.
All right, as to the charges previously listed, how do you plead, Mr. Edwards?
I plead guilty.
All right, I accept your guilty plea. Is there anything additional from state or defense?
No, Your
Nothing
Honor.
further, Your Honor.
All right, best of luck to you, Mr. Edwards. That concludes your case. All right, and we're still holding on that one position, but Ms. Lewis, can we go ahead and review the state all-purpose calendar so that those who need to leave and are only with us for competency can go?
Yes, I can. We're gonna start with the add-on calendar. Is everybody here? Can you hear me?
Yes.
Okay. Alright. On the add-on, position number 1, the defendant was released. The case is reset for the notice. Position number 2, on the add-on, defendant bond was amended to a $3,750 signature bond through the jail. And that case is reset for the notice. Position number 3 was a plea on the add-on, and position number 4, add-on, was a plea. And position number 5 on the add-on was a plea. Going to the original calendar, position number 1 is reset for May the 3rd SAP calendar. May the 30th SAP calendar. Position number 2 and number 3 was a non-negotiated plea. Position number 4, defendant was released. The case is reset for the notice. Position number 5 was a plea. Position number 6, the defendant plead not guilty. Case is reset for trial for the notice, waiver arraignment. Position number 7, same announcement. Position number 8, it was a plea. Position number 9 was non-pros. Position number 10, defendant plead not guilty. Case is reset for trial for the notice, waiver arraignment. Position number 11, case is reset for trial for the notice. Same announcement from 10. Position number 12, defendant was released, reset for the notice. Position 13 was a plea. Position 14 was non-pros. Position 15, reset for SAP May the 23rd. Position number 16 is reset for the notice. Position 17, reset for the notice of bond modification of a $2,000 SOB through the jail. Did you guys get that? I thought I heard something. Okay. Position number 18, reset for the notice. Defendant was released. Position number 19 was a plea. Position number 20, defendant was released, reset for the notice. Position 21, 22, 23, and 24 is reset to next week, SAP counter for 5/23. Position 25, reset to May the 23rd. A bond was added, a $1,500 surety bond. Position number 26 and 27, we're still holding. Position 28, defendant, plead not guilty, cases reset for trial, further notice, waiver of arraignment will be submitted. Position number 29 was a plea. Position number 30 was non-pros. Position 31, the defendant was released, the case reset further notice, same announcement on 32. Position 33 was a plea. Position 34 was non-pros. Position 35, 36, 37, 38, 39, defendant was released, the case is reset further notice. Position 40 was a non-negotiated plea. Position 41 was non-pros. Position 42, 43, 44, and 45, I have reset for SAP for 5/23. Any questions, concerns, or corrections? Okay, we're just ready for the DV counter.
You mean competency?
I mean, not DV counter, competency counter.
We do have competency. All right, we're gonna take a very short 5-minute break, and then I'm gonna go into that breakout for the competency calendar. Who is co- it's Mr. Bartels, and is it still gonna be you, Miss Falk, for the competency
Yes, Your
calendar?
Honor.
Okay, we're gonna take a 5-minute break, and then we'll start that calendar. Those who were just here for state all purpose are free to go at this time. Take
Thank
care.
you.
Everybody. Oh, wait, but Miss Vigiletti, what about, we're still holding on your one state all purpose
Yes,
position, so don't go yet.
yes, Officer Norris and Mike McLean are trying to track her down to see if we can possibly address her case today.
Okay, so we'll hold for that one. All right, thank you all. Let's 5-minute break.
Okay.
Your Honor, whenever you're ready, we have, Ms. Keisha Ray.
All right, are we ready to begin the competency calendar?
Your Honor, we could take one case if possible, Your Honor. It's Keisha Ray.
Oh, that's we're able to find the young lady on state on purpose. Okay. All right, let's see. All right, good afternoon, Miss Ray. Your case is 22 CR 005405F. In this case, you are charged with battery. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. As you can see, this particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this. Do you understand your rights and how I'm conducting the hearing today?
Yes, ma'am.
All right, and the announcement, Mr. McLean?
Not guilty, requesting signature bond. Your Honor, she had a failure to appear, and that has caused her to have a $10,000 bond on the failure to appear itself. And we're going to point out a couple of things that would, I see Deputy Norris is showing me some stuff here. The $5,000 bond that is showing on line 1 is in error. And the $10,000 bond on line 2 is, I believe, the correct one. But we would ask the court for a signature bond, and we'll give the reasons as soon as you're ready.
Okay, and you're going to enter that formal waiver?
We can do a waiver. Yes, we'll do that, Your Honor. I'll make a note of that.
Okay. All right. Ms. Falk, please proceed with your position regarding bond for Ms. Ray.
Yes, Your Honor. It looks like the defendant failed to appear. Let's see. She was ordered for release on August 16th of 2022, failed to appear April 25th of 2023 before Judge Richardson. Rule nisi was issued May 2nd, 2023. The bond was actually then forfeited. There was a bond forfeiture judgment calendar on September 13th of 2023, and then she was arrested on this offense. The incident happened back in, August 15th of 2022, and it involved this defendant committing a battery against against the Atlanta, she was at the Atlanta Medical Center. She had been admitted due to seizures. And then while she was there, Miss Ray began to scream for help. The nurse, who at the time is Leila Patterson, was walking by the rooms Miss Ray was in, heard Miss Ray call for help, went into the room, and was trying to get her help and get her back into bed because she noticed Miss Ray had fallen onto the floor. And while she was trying to assist Miss Ray, the defendant began to hit, kick, and scratch Miss Patterson. Miss Patterson's arms had scratch marks, and her right forearm was actually still bleeding when the police made contact with her. I believe I had seen, and maybe I was incorrect, I thought I had seen Miss Patterson here in court earlier. But I do want to state that this defendant has, a total of, it looks like 2 cycles out of Georgia. She also has 1 cycle out of New York, as well as looks like the failure to appear. And I think that is it. So she has a 2015 possession of a forged instrument from New York, where she received 5 years probation. And then she has this case, as well as, sorry, I'm looking at her New York history again. Hold on. And it looks like she has cycle 1, which was a fugitive from justice out of Clayton County, a 2017 charge where she had been previously arrested. And then this offense. And so for that reason, the state would ask that the bench warrant not be lifted and the bond on that bench warrant not be reduced so that we can go ahead and address this case since we have Miss Ray here.
Okay. I'm gonna let Mr. McLean speak. Ms. Lewis, do you know anything about this error that you say? So the bond is 10,000. Okay. All right, Mr. McLean, please proceed.
Your Honor, there are two methods that she and I discussed about not missing court, not missing any notice and that sort of thing. She's going to be at the clerk's office every 3 weeks in person, double checking and not relying upon the mail. However, she does have a stable mail address at her significant other's apartment. And she is a mother of, I don't know how many children, but 3? Okay, and they're minors?
8, 7, 6.
8, 7, and 6 years old, Your Honor. So she needs to get back home and we would ask the court to consider a signature bond under this circumstance. In 2022, on August the 15th, she was having seizures, fell out of the bed. There are medical reasons why this could have occurred. It would be appropriate for us to research that further and present that, Your Honor. But Atlanta Medical Center does not need to be stayed away from anymore because they don't exist. The nurse at the time, I'm sure, is still available, and this case needs to be tried.
All right, I am going to sound for Ms. Patterson. I didn't do that. Ms. Patterson, are you present? Wish to make a statement? And I do have to ask Mr. McLean, what happened with your client missing this court date? You said that she moved, or what was the explanation that you offered?
Okay, if I may have just a moment on mute.
Yes, please.
Does it look like one of the addresses that she had was missing apartment number?
Okay.
It was on O'Hayfield Road, and the address, I'm familiar with that, those are apartments, there's not apartment number associated with it.
Oh, so maybe there's an explanation. Let's see what Mr. McCoy says. Ms. Lewis, I also sent you an email.
I did.
I know you sent me one, and I'm sending you this back right now.
Okay.
Your Honor.
Yes.
In April of 2023, she missed court on the 25th, apparently. Her aunt, Diane Ryder, had died, and she went to New York, and she was there for several weeks, I believe, to be at the funeral. And this is the reason she missed her court date in Atlanta, Georgia. This aunt was so close to her, she basically raised her. She was like her mom. And so she was in New York during that time and pretty discombobulated and pretty much in grief and wasn't taking care of details. And we know that we are not a detail, but it is understandable, I think.
Ms. Lewis has also indicated there may have been an issue with her mailing address at that time. All right, so the error situation, if I were to convert to signature bond, I guess a new order would just fix that. I do understand the state's position and can appreciate it. However, I will give her a second opportunity this time, Ms. Fox. All right, so defendant's surety bond will convert to signature with the same conditions. But please do not miss your court date again, Ms. Ray. This is a second opportunity. I did not have to do that. All right?
Yes, ma'am.
So, Your Honor, I'm going to prepare a bond order based on the 10,000 one, and I'm just not gonna do anything about the 5,000, which we believe is an error.
Will that still, what I don't want is to enter the signature bond and then that 5,000 error holds her in.
Right.
Is there something we can do to address that?
The reason I announced it was an error was that was what Odyssey told me yesterday when I looked it up. It said, this is an error.
It was the error on the jail part. The jail entered the wrong amount on the bond for the first FTA, so they made a correction. So it's the second one. The jail is aware of it. It was an error. They don't want to enter, they don't want to enter information on there.
I
So
just want to make sure that this won't be a problem. Thank you.
no,
Okay.
it won't. It lost, Mr. McLean, make sure you put that FTA number on there. That's on the counter.
Put the
for the
single
bond.
FTA number that is correct. I will do so.
Okay. I
All
appreciate
right.
it.
All right, Ms. Ray, that concludes your case. Best of luck to you. Please keep your address current with the court. And as Mr. McLean has advised, please continue to check on any court dates you may have outstanding.
Can she
All right.
verify her address now? She has an opportunity
Oh,
to do
can
that?
you, yes, can you verify your address while we have you, please?
I have the apartment number and.
Yeah, because it's a missing apartment number again.
Put that in the chat.
Yes, so I need something, because if not, she's gonna miss another court date.
Okay, I'll put that in the chat right now. To Ms. Lewis? Oh,
Yeah,
Yeah.
to me.
okay, yeah. Oh, you ready?
Your Honor, was that SOB jail or pretrial?
That's up each, yeah.
All right.
Is it road or street? Is that Decatur, Atlanta?
It's considered Atlanta, Georgia.
Okay. All right, so those who were here for state out purpose are now excused. If I could be placed in a breakout, I know Ms. Burgess needs to come. Myself, Mr. Murphy, Ms. Falk, Mr. Bartels, and I do need the competency calendar.
I did send it to you, Judge.
You sent it to me? Okay,
I
thank
sent
you.
it to your, the other email, not the work.
Okay, okay,
Did
that
it
might
go
be.
through?
I'm gonna check right now. I'm trying to sign your last order.
Oh,
And
no,
then
I got more.
I'll check it.
I just pulled that one at the time.
All right, and we're waiting that breakout.
Yeah, I sent it.
Ms. Lewis, will you ask Mr. Jordan to put us in there?
I'm gonna do it because I don't know what he's doing. I'll put us in the breakout room.
Okay, thank you.
Afternoon, everybody. This is ACBC. Is the judge and Attorney Bartel ready?
They're still in the breakout room.
Hi, Mr. Jordan.
Hey, no, how you doing? Welcome back.
Who is he?
You have to call your sister.
Is that the clerk?
Give me a call.
Okay.
Okay? Hey, hold on. Your attorney's gonna come on in a few, okay? Just hang tight.
So they're still in the breakout room. They'll be back in a few minutes.
And I got railroaded by a girl named Alicia Heroin at the East Point City Municipal Jail. It was battery and domestic abuse. I'm a battered woman. I'm battered by people like this in the jail. I'm a battered-
Hi, are there any victims here in the courtroom? It looks like it's just staff, but I just want to make sure. Okay, thank you so much.
I've asked her to remove
Okay,
her handcuffs.
Miss
all
Jones,
of
Miss
these.
Ms. Jones, can I speak with you today? I'm the judge. I'm Judge Melanie Williams. I'd like to discuss your matters with you. Will you please have a seat so I can see your face?
I don't want to have a seat.
Okay,
My attorney already told me I'm getting a signature bond. I get better in these situations.
Okay,
I'm ready to go.
let
She
me
just said she
speak.
owns this table and she owns this computer and she owns these handcuffs.
Okay, that's fine.
I own
but
this
let me-
property.
Hold on, Ms. Jones, I do need
My
you to calm
property, and she's
down.
telling me I can't even have my things on her table because she owns it. Please go ahead and just sign the signature bond and let me go. Delete
Okay,
all of these charges.
that's
I'm
not
not a
what's being-
criminal. I have no criminal history. I
Okay,
keep
Ms.
getting
Jones,
railroaded.
you're
Let
not
me
getting,
go.
you're not getting a signature bond today. I need to explain some things
Why
to
am I
you.
not getting a signature bond?
Please calm down and have a seat.
Explain to me why I'm not getting a signature bond.
I'm not gonna explain
Is it
anything
because
to
all
you.
of the charges are getting deleted?
I'm not explaining anything to you. Just sit down. Please have a seat and calm
I
down.
can't sit down right now.
Okay. Can we speak calmly?
Yes,
Can I-
we can speak calmly, but we gotta speak maturely.
That's fine. I just need you to remain calm, all right?
No.
All right, let me
You don't
tell you
have the
your
right
case.
to tell me to remain calm in a situation like this.
I-
You never
all
been
right.
battered. You never been in handcuffs.
All right, Miss Jones. Thank you
This
for.
is metal. I'm allergic to metal.
All right, Miss Jones, let me tell you your cases and explain your rights first.
I
We
know my
must fo-
rights. I don't need you to explain shit to me. I know my
All right.
rights. I'm
All
a
right,
human
we're still
being.
gonna go. I'm still gonna go through what I'm required to do. You can feel free to disregard. Miss Jones, we're
And
here
these charges
today.
are getting deleted.
Let the judge talk.
All right.
No,
Miss-
I don't know who is the judge.
I'm the judge, Miss Jones.
Horrible. I'm my judge, bitch. You're not my judge. I am my
No.
judge.
Okay, Miss Jones.
Yeah,
Well,
you're
let
not my judge, baby.
Th-
No, I'm
that's
my
fine.
judge. I'm the judge over my case. And I said I'm innocent. And I'm not guilty. And the charges are being deleted.
Okay. Miss Jones, you're here today on case
I don't
23.
care what I'm here on. Like I said, you're not my
Okay,
judge.
23 CR
So you're not my judge.
004969C.
So who are you?
Miss,
I'm my judge. I'm the judge of this courtroom.
that's wonderful. However,
Yeah.
Miss Jones, what's gonna happen
However,
next?
nothing.
Your
However,
case is
nothing.
being reset to next
Nothing.
week. You're not gonna okay. Let her, Officer Milton, Debbie Milton, let her know that her case is being reset to next week. she really does need to speak to Mr. Bartel so that he can assist her. I know she's irate. Can she come back?
Ms. Jones? Ms. Jones?
I'm trying to help you, Ms. Jones.
She refused to come back, Your Honor.
Okay, that's fine. Let her know she's being reset to next week, and she really does need to assist Mr. Bartels so that and engage with him. I know that you know all of this, but you know, I'm trying to help her help herself. I enjoyed learning about my own history with handcuffs and the law. That was great. All right, take care. Have a great afternoon. You know what? That's not actually the worst that I've been called on this calendar, though. So that was.
She's having a difficult week, Judge. She's done better than that.
See, I could tell. And you're sure about the results of that? I just have to ask. You don't want to stay this in light of what we saw today, Mr. Bartels. I'm inclined to say maybe we need to stay the course we're on versus an SAP reset. But we're not going to say anything sensitive, of course. But I don't know how we're going to have any results at SAP.
And just to be very candid without, again, being indelicate, normally Thursday SAP is Judge Law and Monday and Tuesday SAP is Judge Morrow. I would suggest if we were to put her on any calendar, it would probably need to be a calendar where these kind of outbursts would maybe be more tolerated.
I understand. You don't have to say what you're saying. I don't think we're going to get anywhere. But what I'm saying, Mr. Bartels, is you're going to put her on SAP. We're going to have this again, in my opinion. So I think you need to stay the course that we're on. Is in my opinion. Do you disagree?
I think that there's a good chance that that'll happen, Judge. But if it does, I think that'll give us one more data point if we decide to go back and say we think we need a new evaluation. You know, I would at least like to try it. And, you know, that'll be more, I guess, support if we do decide to ask Emory to look at this again.
Okay, I just don't want to waste the time of, okay. Tell me.
Can we wait to see what's in the report so that we can see where the conclusion of the report, where that's coming in, just based on the interactions that I've had with Ms. Jones, I'm sure Mr. Bartel has had.
I have to ask, were they better?
Yeah, that's what I would like to see what's in the report, because now, Your Honor, she presents, she's sweet. Like, her presentation when you're talking to her one-on-one is not that at all.
That's correct.
It does not come off in that way, shape, or form. She actually presents extremely intelligent,
I can tell she's frustrated. It's a frustration thing. I understand, and I've seen that before, but in this
I'm not sure if it was you, Your Honor. I'm sure it happened with whatever interactions at the jail. Usually that's not her presentation, but there's not to say that, you know, that can't necessarily tell us whether or not she's competent or not. But I'm interested to see what's in the report before we make any decisions.
Well,
in terms of where that conclusion came from.
Or do y'all want to put it back on the CC counter or keep it on the SAP counter?
Mr. Bartels is saying SAP.
I would ask that it go on an SAP calendar. I think if that's not productive, again, that's another data point. And
can it go to Tuesday per Ms. Fold? Is there any spot on Tuesday?
Tuesday would be
Tuesday. She'll be waiting forever and a day. That'll be a long process. We have
okay, but I think okay. What about the following? I'd rather her be addressed next week if possible, and we'd like it to be a Tuesday. Is it possible at all, Ms. Lewis?
I'll do it. I'm just telling you.
I know it'll be long, but there's no DV reset and there's no other. It's just SAP on Tuesday, right?
No, we got probation. We got like 11 cases on the calendar for probation. And 52.
Somebody's gonna make fine. It's gonna be fine. It's gonna be fine. We're gonna put it on Tuesday.
But the other thing I can't say.
I'm operating that calendar on Tuesday.
Thank you. Tell Judge Morrow it's my fault. I'm sorry, Mr. Bartels.
Judge Morrow.
Judge, I was also going to say, without going into too much detail about the what's in the evaluation, she did come back with a diagnosis of a personality disorder. That is what her diagnosis is, as opposed to schizophrenia or bipolar. And the latter conditions are usually what we see with our clients. They're more amenable to things like medication and education. With the personality disorder, you know, as I've indicated, somebody can really understand what's going on without really wanting to understand, if that makes any sense.
I understand completely. I just don't, I was trying to keep it from going back and forth. We're gonna add her as an add-on to Tuesday. That will be the extra data point. If we're not able to make any resolution from there, she probably needs to go back, CC.
Yeah.
All right?
I would agree.
Okay. All right, well, we have completed state all-purpose, DV reset, and competency calendars. Thank you everyone for their patience this afternoon. I know this has been a long calendar. I've enjoyed seeing you all. I'm not on this calendar very often, so take care, everyone. Have a good afternoon. If Miss Lewis could stay on with me for a moment.
I will.
Thank you, Judge. Good to see you.
Thank you. Take care.
Thank you.
All right, bye-bye.